15 is a contempt. I'm still waiting on instruction from the finalist. So time may be granted.
You're appearing for respondent?
9 and 10, but there was an instruction on the last order. I was started to obtain certain instruction from the finalist. So I'm still waiting for that.
Mr. Im Tiam Song appearing for respondent number 9 and 10 has prayed for some time to receive the instructions as directed by this court.
Yes, Lord.
Yes. Accordingly, prayer is allowed. List the matter after.
3
Lordship,
weeks.
Any
on the last
objection?
occasion, I was directed to take steps upon respondent 5 by way of trustee.
Okay.
And then to that effect, I filed an affidavit. So it may
Reflected.
yes, Lord.
Okay, so list after 3 weeks. Stop. Learned counsel for the petitioner has also submitted that the trustee service on respondent number
5.
5 has been served and the affidavit has been filed to that effect. Stop. This after 3 weeks.
May I please your lordship?
Yes.
Am I audible, my lord?
Yes, yes.
My lord, I would like to make a mention in item number 17. AB
Okay.
anticipatory bail application 19 of 2025.
17
Lord,
years.
Yes, my lord, on that matter, on the last occasion, the honorable court posted the matter today. Interim relief was not being granted and on that day. So we have challenged that order before the Honorable Apex Court with diary number 31070/2025. So it may come up, the matter in the Supreme Court may come up any point, tomorrow or day after tomorrow it may come up. So this is what I want to apprise, because the interim relief was not being granted in light of the constitutional bench judgment. So we have challenged it. So that's why I would like that your lordship may kindly post the matter next week, because let us see what happens in the Supreme Court.
Okay, I'll just send the prayer of petitioner. Let's see it next week.
My lord, let it be reflected that SLP has been moved with diary number 31070.
Wait, 31070.
70/2025.
2025. Item 17. Learned counsel for the petitioner as Board Kohima submits that an SLP has been preferred in the Supreme Court with diary number 31070/2025, which is due to be listed any day.
Any day, no, my lord, it may come up within the next 2 days. It may come up.
Within the next 2 days, and accordingly he has prayed that this matter may be listed next week. Stop. Praise allowed. List the matter next week. Learned counsel who appears for the state. Okay, and Gami appears for the state respondents. Yeah, list like next week. Yes.
Oblige, my lord.
Please, Lordship, I beg to mention hearing at number 33.
Yes.
Lordship, 3 weeks time will be granted.
For counter affidavit.
No, I have already filed.
Learned additional AG. And Team Song has prayed for 3 weeks time. At least after 3 weeks, learned counsel for the petitioner has no objection. This is 33, 32. Oh, okay, this is different matter. Okay, list after 3 weeks. Yes.
My pleasure, Lordship. I beg to mention hearing item 32. As instructed by the petitioner, your lordship, I may be allowed to withdraw with liberty to file afresh.
Item 32, learned counsel for the petitioner as willing, please for liberty, permission to withdraw the writ petition with liberty to file afresh. Accordingly, the petition is disposed as withdrawn. Petitioner is at liberty to file afresh. Yes, learned counsel for state respondents, wish to pray, additional AG is present.
Oblige.
Please, your ladyship. I mention item number 21. As per this court order dated on the last occasion, I have taken step upon respondent 2, 3, and 4 through paper publication, and I filed my affidavit only this morning. As such, if this matter may be listed after a week for admission hearing.
Item 21,
Right.
Learned Counsel for the petitioner, James Newmai, submits that
Yeah,
the,
please.
the,
May it please your
notice
lordship.
on- yes,
For the respondent number one, lordship, I filed the Baglatnama today.
okay, one
Yes, lordship. Lordship, the applicant may be directed to furnish the IA copy,
copy.
lordship.
You had served notice on 1 and the
2,
paper
3 and
publication, or 2, 3 and 4.
Yes, your lordship.
Yes, what did I say? Submits that the respondent number 3 and has been publication, and the same has been filed this morning. Accordingly, please for listing the matter next week as admission in the admission column. Stop. Prayer is allowed. Learned Counsel has entered appearance for respondent number 1 and has filed his Baglatnama. Counsel for the petition, appellant shall supply copy of the IA to the Learned Counsel during the day. Yes.
Your addition, similar prayer for item number 40. May it be listed after a week for admission hearing.
May it please the
Item 14,
lordship.
yes.
I've talked to the principal counsel for the appellant. So whether this matter can be listed on 23rd of this month,
23rd.
lordship.
List the matter on 23rd.
Lordship.
And Learned Counsel for the petitioner is present. Counsel for respondent. For respondent.
Respondent number one.
Inti Wapang is present.
May it be listed as hearing list, your honor.
Will it come up in admission?
Hearing, lordship.
Notices are
40.
complete.
Lordship,
Notices are
yes.
complete.
Completed.
Lordship, it was listed yesterday. However, it was posted for hearing today. However, now they are praying for time. It was listed yesterday.
Let it be
Lordship.
admission, it's okay. Yes, admission column.
Lordship, much obliged.
May I please, your lordship, to mention hearing item 28. The counsel for the petitioner, if this matter can be listed on 9th of June.
9th of June,
Yes, lordship.
28, on the prayer of the Learned Counsel for the petitioner, list the matter on 9 June.
Interim may be extended.
Interim passed earlier shall continue till the next date.
Obliged.
Please, Lordship. Lordship, I'd like to mention item number 29, Your Lordship. Yes, Lordship. Your Lordship, if Lordship may kindly grant us 2 weeks' time to file our affidavit in opposition.
You're appearing for?
For the sole respondent, Your Lordship.
Respondent.
Yes.
Learned Counsel.
Medovero.
Medovero, appearing for the respondent, has prayed for
2 weeks' time. Your
2
Lordship.
weeks' time to file his affidavit in opposition. Prayers allowed. Learned Counsel for the petitioner is present. So, list the matter after 2 weeks.
Much obliged, Your Lordship.
May I please, your lordship?
Yes.
My lord, I am appearing from PC, my lord.
Yes.
My lord, in I beg to mention item number 34 and 35 of today's hearing list, my lord.
Item,
34 and 35, my lord.
okay. Yes,
My lord,
what-
here, my lord. My lord, here, my lord, the accused petitioner was directed, my lord, to appear before the Commissioner of Police, my lord, on, my lord, 31st of May 2025, my lord. But, my lord, due to the flood, my lord, in Gauhati city, my lord, in Assam, they could not appear, my lord. So therefore, my lord, I'm praying for some time, my lord, so that the petitioner can appear and cooperate with the investigation, my lord. My lord, the fixed date, my lord, and time, my lord, will appear before the investigating officer, my lord.
You were directed to appear on 31st. 31st.
Yes, my lord. I have filed an affidavit, my lord, 31st of May 2025, my lord. My lord, as the petitioner could not appear before the investigating officer or the Commissioner of Police on such date, my lord. So on last day, my lord, yesterday, my lord, I have filed an additional affidavit showing that, stating that, my lord, that the petitioner could not appear due to the water lodging at the Jorabat area, and the transportation has totally been closed, my lord. My lord will find in my affidavit, my lord, in item number 15, my lord, filed on, my lord, yesterday, my lord, 2nd of June, my lord, 2025, my lord, And in connection with this, my lord, at page number 11, annexus 7, my lord, the government of Assam also issued, my lord.
The affidavit has not reached the court. Wait.
My lord, same may be allowed to bring on
Let it
record,
come
my
up,
lord.
let it come up. Let it come up. Okay.
My lord, my lord, my lord. My
Follow
lord,
the reaches.
every,
You mentioned
my-
the matter reaches.
my lord, my lord.
Yes.
Highly obliged, my lord.
Lordship, Your Lordship, I beg to mention item 22 to 24 on behalf of Bandung Wapang. Lordship, kindly this matter may be listed after 2 weeks since the council is indisposed.
Respondents, State of Nagaland.
Your Lordship, I've taken their consent.
I'm for respondent 1 to 3, Lord.
Senate Council, such and such, appearing on behalf of Mr. Bandang Wabang, has prayed for listing the matter
2 weeks.
after 2 weeks as the leading council is indisposed. Stop. Prayer is not objected by the learned government advocate V.C. Momi, appearing for respondent number 1. List the matter accordingly after 2 weeks.
Much obliged.
Please, Lordship. Lordship, I beg to mention item number 40 from the supplementary cost list. I'm appearing on behalf of Mua Jungla, who's the leading counsel for the appellant. Lordship, on a consensus prayer, this matter can come up on 23rd of June, Your Lordship.
3rd of June.
Yes.
Learned Council, such and such, mentioning on behalf of Ms. M.S. Moajungla, has prayed for listing the matter on 23rd June. Stop. Learned Council, M.T. Wapang for the respondent has no objection. Accordingly, list on 23rd June.
Much obliged, Your Lordship.
May it please your Lordship. Lordship, I beg to mention item 37, Lordship. Lordship, as per the request made by me on behalf of my senior counsel AGO yesterday, the Lordship has been gracious to pass over.
37.
Lordship,
It's
37.
supplementary.
Lordship.
Yes.
Lordship. Yesterday it was listed and today it was passed over.
Yes, yes,
Lordship.
that IA.
Yes, Lordship.
Yes.
However,
So what
Lordship,
happened?
I've been informed by my senior counsel last evening only that his medical review could not be completed yesterday. So it is to be continued till today.
On your prayer only, it was listed
Lordship,
today,
Lordship.
it's passed over. So next week,
Lordship, then if
Lordship,
the other
or
or
counsel
it can
doesn't
come
have
up along with the main case.
Lordship.
Lordship, since it's
For final
largest,
disposal, Lordship.
When do you want them?
Lordship,
Tomorrow?
Tomorrow,
Tomorrow?
after
No,
the,
tomorrow is Wednesday.
after the.
Thursday.
Thursday.
Lordship, in that case, it can be on Friday.
Friday is
Lordship,
okay.
we have one fixed matter on Thursday, Lordship.
Learned Council, such and such, praying on behalf of Mr. Azo, has submitted that the medical review of Mr. Azo could not be completed and hence he is unable to attend the court today. He has prayed for listing the matter on Friday. Learned Council for the respondent prays that the matter may be taken up without delay as there is urgency. Accordingly, list the matter on Friday. That is
Sixth.
6th. Yes. 6th. Yes.
Much obliged.
Obliged.
Lordship, there's an interim.
The
In the main
interim passed
report.
earlier shall continue till the next date.
Much obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 30, which is in hearing column.
30.
Yes, yes, Lordship.
Yes.
Lordship, the principal counsel is suffering from nerve issues, so he could not turn up before this honorable court. So kindly let this matter may be listed after 2 weeks.
Who's the counsel?
Sir Vikramjit Dhanwar.
Respondent.
Respondent 1, Lordship. Lordship, in that case, let it be come up on 23rd, Lordship.
23rd. 23rd.
All right, Your Lordship.
Learned Council, such and such, appearing on behalf of Mr. V. Debnath for the respondent, has prayed for listing the matter on 23rd June. Learned Council for the appellant, M.T. Wapang has no objection.
For the respondent, Lordship. Oh, Lordship,
No,
Lordship.
here
Appellant,
it is,
Lordship.
appellant,
Lordship.
yes. List the matter on 23rd June, 2025. Yes.
All right.
Right, Your Lordship.
for motion from the supplementary cost list, item number 36.
There's another note by the-
May I please, Your Lordship?
Small one. This is pages left. It's there on my table.
My lord, this IA is in relation to this thing, civil revision 11 of 2023. I'm yet to file a copy to the opposite party. The opposite party I'm explaining today. My lord, this IA is in relation to the previous IA 111, wherein I have prayed to the court to withdraw my my IA and file afresh.
Hmm.
So my previous IA in 111, I filed for condonation of 47 days. But since I have not checked this thing document nicely, I kept it. It came to light that under Article 131, wherein revision is for 90 days. So it is within the ambit of 90 days. So let the matter be heard as the condonation that is being prayed for
No,
45.
no, I don't understand what you're trying to say. Last, you had filed an IA
I filed an IA
earlier.
praying
yes,
that there's a delay of
for
47
condonation of
days.
delay.
Yes. But after checking out the rules, it came to light that that 47 days is within the ambit of 90 days.
So there is no delay. You're
There
trying
is
to
no
say.
delay, exactly.
Yes.
Lordship, I am just one senior colleague has just handed me over this, but Lordship, since this matter pertains to challenge of an order going as far back as July 2022,
Hmm.
if Lordship, notice may be issued to the party
Yes, yes,
so
we'll do
that
that.
I'm
But
in copy and
regarding
proper
the
instruction.
delay, you just check up.
Lordship.
This application, this is IA 79. This application has been filed under Section 5 of the Limitation Act 1963, praying for condonation of delay of 47 days in filing the connected civil revision. At the outset, learned counsel for the revisionist / petitioner, Sri Elivil Zhao, has submitted that on going through the related law, there is actually no delay in filing the civil revision. Stop. Learned counsel. Mr. Eliz Kiri appears for the respondent and has prayed for some time as he has received the copy of the IA only this morning.
Lordship, I beg your indulgence.
for
If
him
this
it
can
is-
be sent via registered AD so that I may receive proper instruction.
It has to be served to the party, actually, not on the council. Let it be served on the party, yeah.
Fine.
Yes, issue notice, delete that portion about the council. Issue notice on the respondent. Petitioner shall take steps by registered posts with AD as well as usual process. The notice is made returnable in 4 weeks.
Obliged.
For admission, item numbers 1 to 13.
May it please, my lord.
Yes.
Lordship, the last order, I have checked from the registry, the files, and I have been informed that the service notice has been sent to UGC, and on our part, we have filed twice. So it has been sent to UGC. but they are not,
Just that way, order such and such, an order was passed directing to implement the UGC accordingly one IA was amended first title. You have
yes,
inserted-
already, it's also there.
Okay, so service is not complete under UGC.
UGC we have filed twice, and there was no noting on the file, so we checked it up, and we were informed that it has already been, service notice has already been sent to UGC through registry on 25/4/2024. That was
25?
25/4/2024. From the filing section, it has been informed.
But in the office note, that is not reflected.
That is in writ petition 188, Lordship. 188.
This one is 208.
188,
Okay, give me
writ petition,
188.
because this 208 and 340, they were tagged later on. The first writ petition, 188 to 189,
Okay,
were the first batch of writ petitions. So
29/5. 29/5.
that is what?
25.
29/5.
UGC is respondent 12.
Respondent, yes, respondent 12. UGC was implemented as respondent number 12.
Yeah, that's why. Notice has been issued upon respondent 12 by registered post with AD. Return service awaited.
Lordship, since last year, Lordship, I just humbly pray before this honorable court that the writ petition 340 was just tagged just recently on 24/4/2025. It was separated from the rest of the bunch of the writ petition because the rest are filed into 2023, and this writ petition 340 was filed separately in 2022. So Lordship,
No, but after respondent number 12 was impleted, you have taken steps only once. Because the office note indicates that notice has been issued only once.
we filed twice. But when the matter came up after the implement, we filed the first instance, and they said that we have not filed. Lordship, however, here the question is, whenever we file after implement, we will not leave it out, and when we file it, the notice is kept in the box. So that is normal practice. So the first one that we filed, it is said that we have not filed notice. So the second time we took step,
We'll wait for some time then, because it's the last order is of 29/5. 29/5. 29/5/25. Okay. So it says notice has
29.
been issued is 29/5.
Lordship, that is the.
Today is only the 3rd.
That is the problem here, Lordship. Lordship will kindly see that we have filed it last year. Right after there is something, it cannot go on 25/5 because it has been.
29/5.
Yes.
29/5. Notice has been
29/5.
issued upon respondent 12 by registered post with AD, such and such, return service report awaited.
That's why we have filed it
just
in the
wait
month of March, when the implement was done in 2024. There is some implement was done in 2024. For us,
You check up the records later. No.
for us, we filed the notice.
See, this is in pursuance of order dated, court's order dated 4/4/24, passed in IA 31 of 24. Okay, so before the court's order, you couldn't have filed the copies, you couldn't have served a notice.
No, no, Lordship. Here, 31. The
You sort it out later. From
IA
office note
is-
dated 29/5/2025, it indicates that in pursuance of order dated 4/4/24, passed by this court in IA 31 of 2024, steps had been taken by the petitioner. And office note indicates that a notice has been issued upon the respondent number 12 by registered post with AD, and return service report is awaited. Stop. Accordingly, await.
Your Lordship, if I
yes,
may,
please.
so in the previous order, the Honorable Judge has given an interim order collectively. However, the interim order is only limited to our read petition 340 of 2022. So it may be noted that the interim is only limited to that particular petition.
340.
And all along, this has never been tagged together. 340 has always been this.
Otherwise, Lordship,
340 of
2022.
2022.
Otherwise, Lordship, whether this, since this one, the first writ petition 340 is separated from the bunch of the writ petition where in 188 notice was to be served. This 340 has no connection with that service of notice. So Lordship can it be segregated? Because we also having 15 writ petitions separately, we also could not segregate, and there is some heavy hearing on that.
Allow me to make a small submission on
Yes,
that.
yes.
On the last occasion,
Mm.
340 was separated from the other rate petitions, but on the last occasion, after hearing the matter, so the advice of local court was of the view that it should be tagged together because it is arising out of the same issue, challenging the same appointment order. The result, the honorable judge was of the opinion that it should be tagged
No, I'm
together.
praying before this.
There is no question of separating again.
I'm praying before this honorable court, and it is the discretion of this
No, no,
honorable
no.
court. I'm not
See, 340 is complete as far as service is concerned.
everything. And this is 2022 matter.
Let's say that as far as 340 is concerned, service is
Service is
complete.
complete.
All-
As far as the other writ petitions are concerned, we have
Only-
to await the service report.
There is one aspect where we filed since March that after the implement. Now where it is sent only on 25th, 2025.
The office note indicates that.
Yeah, that's why,
this-
that's why.
Yes,
Lordship,
steps were taken after 4/4/24 order.
in
Oh,
2025.
24/24, okay, in 25.
That is what I'm saying, Lordship.
Yes. Order was a 4/4/24, but.
Then
office-
how comes?
Office has served on 29/5/25.
I just hope that there is no
Or
sabotage.
maybe some clerical
That
error.
also I went and clarify myself, and only then they have sent. Why should it be kept pending for nearly a year? Not sending to UGC. This is just a delaying tactic.
It is observed that the order of the court was dated 4/4/2024. Stop. However, the notice has been sent by the registry only on 29/5/2025. Await service report on the respondent number 12. As far as the
Writ petition
writ
340.
petitions- No, 340 not required. As far as the
Writ petition
other writ-
188.
other writ petitions are concerned, except WPC 340 of 2022, where the service is complete. Stop. List the matters after 3 weeks.
Your Lordship,
Much
but
better.
Yes.
may the interim.
And yes, and learned counsel for the UR4.
And for the various respondents in the
con-
189. I can
Also
submit-
for
I
the
can give them
respondents,
this.
further submits that the interim order extends only to WPC 340 of
2022.
2022. Accordingly, it is clarified that the interim order dated
Interim order dated 16/12/2022.
16/12/2022
2022.
Is only in respect of WPC 340 of 2021.
In 340, Lordship, the interim order may be continued.
And in 340, the interim order bus area shall continue till the next day.
Also, I pray that Lordship,
Your Lordship, the interim date is 26/5/2025.
Change the data, 26/5.
2025.
2025 in WP 340, okay, and that will continue till the next day. And
Lordship, in the next time fixed as a fixed matter, and if UGC does not appear, let the matter be, because recently also what the record on the record is placed, only through that it will be heard, even that has been passed in the matters.
340 of 22, they are appearing. Is UGC a party in?
No,
340
no,
of
no,
22
no,
also?
no,
They are not a party.
no, they are not a party, only in 188. So next returnable date, if the UGC doesn't appear, it cannot go on like this, Lordship. It's March to 2024. They have been impleted and we have filed twice.
Let's see.
For admission, item number 15.
May I please, Your Lordship? My Lord, I am appearing through VC. Am I audible, my Lord?
Yes, yes.
Please, my Lord. My Lord, this is the petition for appointment of arbitrator. On the last date of hearing, I, my Lord, produced one judgment of Honorable Supreme Court that once the parties approach to the court, then both the parties seize their right to appoint the arbitrator. Now it is only for the court to appoint the arbitrator. So I am praying for the any retired High Court judge, Honorable High Court judge may be appointed as the arbitrator.
My lady, my please, my lady.
Yes.
Ladyship,
On the last occasion, I think you prayed for time to get some instruction.
yes, I've received some instruction only this morning. So, but in the meantime, also we are not outside the court talks with the parties were going on. If
no such talks, my lord.
No, they have only yesterday night they proposed to have the settlement at Kolkata and Delhi. What is that?
No, I only propose, you were saying that you have appointed an arbitrator and we are also mentioning that in the petition that we are appointing an arbitrator. Let the court appoint the honorable court appoint the umpire in this case and the matter be place of arbitration be either Kolkata or Gauhati High Court.
So I'm exactly talking about that.
So but I have been informed that you have denied the possibility of arbitration at Kolkata and Gauhati. Therefore, I am making this submission.
Yes, the parties has approached various courts and the judgment of like Chandigarh.
Yes.
All this has to send this back. I think you should.
Yes, then let it be Kohima. Let it be Kohima. I agree to it. And let my lord may appoint any retired honorable judge of the this honorable court as the arbitrator. You will come to Kohima, my lord.
Yes. In the meantime, let us also take your prayer. What your prayer in your petition?
Yes, kindly see.
Yes, there your prayer is not for sole arbitrator also. Is talk about a sole arbitrator or arbitral tribunal. Consists members. I think that also.
But now they are agreeable to sole arbitrator, isn't it?
Yes, yes. Sole arbitrator. Any retired honorable judge of this honorable court that will serve the purpose.
Yes.
And the place of arbitration be at Kohima. You will come here.
Is that okay?
But having said that, only
it should be okay.
Instructions. So if I may be given
tomorrow
or after tomorrow Wednesday
or Thursday.
Yes.
Thursday.
Let me keep it for Friday then. Friday or next Monday.
Friday is not convenient for me. Then in that case, Tuesday, next Tuesday.
Next Tuesday is right.
Tuesday, okay. 10th.
Yes.
10th. List the matter on 10th.
10th.
Tuesday will be 10th.
Yes.
My lord, 10th I am not available. My lord, I am so sorry. 10th I am not. 9th, if it can be 9th. 9th. 9th is right, my lord.
Okay, 9 June. With the consent of both the parties.
And my lord, let it be disposed on the next date of hearing.
And the government advocate, Angami will obtain the necessary instructions.
I'm so grateful.
For admission, item number 16.
My lords, in this case, last time the official respondents have taken time to file reply. Still reply has not been filed. So I don't know whether they want to file reply or not.
I'm appearing for respondent number 1, Lord.
So if the state doesn't want to file reply, my lords can keep it for final hearing, subject to my brother's convenience.
No, Lordship, here the main party is the
Filing.
Lordship, here the main respondent is respondent number 2 and 3, Lordship.
But my lord, but says FIR is by a state, so state will have a be the necessary party. But anyway, we can assist the court at the time of arguments.
No, but respondent 2 and 3, they have their standing counsel.
Lordship.
Yes, standing counsel is there. Notice has been served.
Yes, my lords, service is complete.
Okay.
In fact, my lords, we have collected some more documents which are very helpful. So when the argument takes place, I will be showing this to Honorable Court, where the state has already accepted in fact, rejected the report of the CAG. So after that, nothing survives. And that was not taken into consideration when the FIR was registered and investigation going on. The state did not accept. The secretary has specifically rejected the report of the CAG regarding any embezzlement or anything. So, my lord, this is, a long harassment going on since 2015. So, my lords, if the state doesn't want to file reply or the other respondent don't want to file reply, my lords can hear me for the final disposal of the matter.
Respondent 2 and 3 had entered appearance.
No,
My lord, they have not entered appearance, but the service has been completed.
their appearance is necessary.
Yes, their appearance is necessary, Your Honor, Counsel.
But my lords, if they don't appear, how can we force them? We can only serve the notice of the Honorable Court. So somehow they are not interested or something, I don't know. My brother, of course, is appearing for the state, and the state is also a necessary party because any FIR is by a state, millets. So state has a
3 weeks time.
Yes. On 8/5/2025, learned government advocate Mr. Veto Zimomi had prayed for 3 weeks' time to file affidavit in opposition. So today, when the matter is called, learned counsel has prayed for further time and has also submitted that respondent number 2 and 3 are the necessary party and they need to be represented. So accordingly, the learned government advocate shall seek instructions with regard to the appearance of respondent number 2 and 3. And also file additional affidavit on behalf of the state respondent with number 1.
Number 1.
If so advised. Stop.
my lords, may say the final opportunity, my lords, because of course I am protected by the Honorable Court, but still, my lords, it is a almost 11 years old matter, my lords.
We will see. Yes.
Final opportunity, my lords. I will be grateful.
3 weeks as last opportunity.
My lords, my lord, there is IR, my lords. IR may be continued.
Interim order.
Yes, my lord, there is an interim protection given to me, so that may kindly be continued.
Continue till the next date.
It was in the first order, my lords.
Yes. Extended.
My lords, much obliged. Grateful, my lords.
For all item numbers 19 and 20.
Please, Your Worship.
Yes.
Worship, we have taken steps yesterday upon the respondent number 2 and 3. So the service is still awaited.
Also for the appellant, research and search submits that steps have been taken. Fresh steps have been taken for notice on respondent number 2 and 3. When? Yesterday?
Yesterday, yes.
Okay. Stop. Learned counsel for the
Respondent 1.
respondent 1 in Kiwapang appears. Stop. List the matter after 4 weeks awaiting service report on respondent 2 and 3.
Obliged, Your Worship.
For orders, item number 25.
Mr. Lordship, Lordship, kindly pass this matter for the day. Due to some personal difficulty, my senior will not be able to come.
Pass over. Who's your senior?
I am the launcher.
It is submitted that Mr. IMT Longchar is indisposed, and accordingly placed for listing the matter tomorrow.
Yes,
Tomorrow?
Tomorrow is
No,
Wednesday,
tomorrow is
Lordship, Wednesday.
Thursday,
Thursday.
for day after tomorrow. Accordingly, list the matter on such and such. Day after.
Much obliged.
For orders, item number 26.
Yes, anyone, item 26.
Yes, Lordship.
Yes.
Lordship, I'm for the petitioner here, and it's for compassionate ground appointment. My wife has expired in 2004, Lordship. And thereafter, I've applied to the respondents, railways.
Affidavit in opposition filed.
Yes, Your Lordship, it's fixed for hearing you. Lordship, may I humbly take your Lordship to para 12?
If there is a scheme, do you have a scheme?
Yes, Your Lordship.
What are you saying in your affidavit in opposition?
Your,
Eligible?
yes, Your Lordship, Your Lordship, in my affidavit in opposition,
Respondent 1 to 5.
yes, yes, Your Lordship. Your Lordship, there is a rules scheme is there. The master circular number 16, that is annexure B, page number 11. Page number 11.
Appointment and compassionate
Yes.
grounds.
Your Lordship, that is appointment on compassionate grounds. Your Lordship, clause 5 at page number 14. Clause 5, page number 14. I may be allowed to read the condition for the compassionate appointment, Your Lordship. The time limit for making compassionate appointment. Normally, all appointments on compassionate ground should be made within a period of 5 years from the date of occurrence of the event entitling the eligible person to be appointed on this ground. This period of 5 years may be relaxed by the general manager subject to the following condition. Number 1, the power shall be exercised personally by the general manager. It shall not be delegated to a lower authority. Number 2, the case should not be more than 10 years old as reckoned from the date of death. The widow of the deceased employee should not have remarried. The benefit of compassionate appointment should not have been given at any time to any other member of the family or to a near relative of the deceased employee. The circumstances of the case should be such as to warrant relaxation of the time limit of 5 years. The reason for relaxing the time limit should be placed on record. The request for compassionate appointment should have been received by the railway administration as soon as the son daughter to be considered for the above relation power. Your Lordship.
Something is wrong. This is not a continuation. To be considered for what? The request for compassionate appointment should have been received by the railway administration as soon as the son daughter to be considered for it is incomplete.
Lordship. Your Lordship, however, the condition is that the application should be moved within 5 years. And if beyond 5 years, then application for exemption or containing the delay should be moved before the general manager. Your Lordship, in the instant case, the petitioner wife Your Lordship, at paragraph 6 on page number 2,
Page 2
page 2
of your affidavit.
of my affidavit, paragraph 4, Your Lordship, the petitioner wife, third line of paragraph 3, let Kiria Basfor expired on 23/5/2004. She joined service on 2/8/99. A pension payment order was issued in favor of Lal Babu Basfor. However, it is denied that the answering deponent received application as there is no such record available at deponent office. Even otherwise, it is beyond comprehensible as to why the petitioner made compassionate ground appointment application after 5 years of demise of his wife. At paragraph 6, Your Lordship, that as regard to the statement made in paragraph 8 of the writ petition, the answering deponent respectfully admits to the extent of the provision of the railway establishment rules and labor rules is concerned, however, does not admit anything which is contrary to the records. The answering deponent respectfully state that a consolidated master circular number 16 has been issued by the railway authority pertaining to the appointment on compassionate ground. The rule which we have read just now, Your Lordship. Clause 5 to the master circular categorically state that normally all appointments on compassionate ground should be made within a period of 5 years from the date of occurrence of the event entitling the eligible person to be appointed on this ground. The answering deponent respectfully state that on all assumption, the application that the petitioner alleged to have submitted before the respondent authority, the time limit for making compassionate appointment has already lapsed unless a specific reason has been mentioned of such delay. The petitioner first application was submitted on 6/8/2009. 6/8/2009, wherein the petitioner wife died on 23/5/2004. Therefore, it is understood appearing before this honorable court after 17 years, seeking compassionate appointment after the dismissal of his wife cannot be a good reason or was suffering and that the husband was dependent on his late wife. The answering deponent further respectfully state that it is clearly mentioned in RBE number 42 dated 21/3/18 issued by the Director Railway Board that appointment on compassionate ground is not source of recruitment. Your Lordship,
So on this delay ground, you are not.
yes, Your Lordship,
the
first
appointment.
of all, before going to the merit in the case, Your Lordship, this she was an employee in the railway, and this is related to the service matter. So before approaching this honorable court, Your Lordship, they should approach the tribunal, a central administrative tribunal, since it is related to the service matter, but they have not approached there. Your Lordship, and on the merit, if we come here, Your Lordship, see, the rule says that.
Since you're disputing, let him submit. Yes.
May I humbly submit,
Yes,
Your Lordship?
yes.
May I just take Your Lordship to para 9 of his affidavit in opposition, of the respondent's affidavit in opposition. uh,
Para 9.
para 9. It's at page 4. And the relevant part is at page 5, Your Lordship. There in the last 3 lines, the respondent has said that he cannot claim relief at this belated stage. Had he been vigilant enough, he could have sought redressal as per the scheme. They're saying that had I been vigilant enough, I would have got the redressal. They're admitting that. Now I'll come to the main point, Your Lordship. At para 10, they're saying that as regards to the statement made in para dash and dash, the answering deponent respectfully states that this honorable court cannot come to the rescue of such persons where he himself is guilty of waiver, wherein the petitioner is constantly abandoned an existing legal right in which he could have enjoyed. Now, Your Lordship, may I humbly take Your Lordship to my affidavit in reply, which I have filed. Is may directly take Your Lordship to annexure to page 10. Lordship, this is the reply given by the respondent in 1/3/2007. Dear, may I read it for you, Lordship. In response to your application dated 28/4/2006. This is sufficient enough to prove that Your Lordship have made my application in 2006. In response to your application dated 28/4/2006, this is to inform you that late Kiria Basford dash and dash was appointed as railway on compassionate ground consequent to the death of her husband and so and was drawing her family pensions regularly from bank without submitting any remarriage certificate as certified by the pension disbursing bank. Further, she has not submitted any family declaration nor availed or privilege pass and medical facility. Moreover, she expired on 23/5/2004. After 2 years through your application dated 28/4/2006, annexing marriage declaration, treatment papers claiming to be husband of FS dues and CGA, which cannot be accepted in office if any declaration submitted by the ex-employee. Now, this line next is important, Your Lordship. Hence, your claim for final settlement dues and compassionate ground appointment cannot be considered for want of proof of your genuineness as husband. So they were questioning my genuinity as regards to the husband, Your Lordship. And consequent thereupon, I produced the succession certificate and final settlement was settled in my favor and I'm getting the pension. Here they've said that your claim for FS dues and CGA, compassionate ground appointment, cannot be considered. But FS was considered. I've been given the pension payment and pension payment order is also annexed in my main rate petition, Your Lordship. And therefore, I am eligible for getting this compassionate ground appointment, Your Lordship.
28/4/2006.
28/4/2006.
And the demise was? Date of demise?
23/5/2004. They have denied me on 1/3/2007 that I am not eligible. But again, I've got the pension payment that FS was decided in my favor by them only.
Your Lordship, I have a request, Your Lordship. Your Lordship, this case was previously handled by some other counsel. And recently, the brief was endorsed to me. Your Lordship, this reply is not in my record, Your Lordship.
Your Lordship, I was anticipating something like this will happen. And because time and again, I've seen learned counsel doing this.
No,
I can give him a copy now also, Your Lordship.
Your Lordship, in that case, either tomorrow or day after tomorrow we'll fix it because in my record, this reply was not there, Your Lordship.
You see, because his application seems to be 28/4/2006, which means it's within 2 years.
Your Lordship, that's why Your Lordship kindly, I will seek the instruction from my department.
This affidavit in reply was filed by me in 2023. Thereafter, he's here in this case
Yes,
for almost
18/3/2023.
23, and almost 2 years he's here in this case, Your Lordship. So
Yes,
now at this point,
Suddenly, how come you don't have this?
yes,
Yeah, your lordship, actually, this hearing was one after another, it was fixed, but I was not aware that the affidavit in reply was filed. Because I came at this stage only, your lordship.
in fact, in one such occasion, they prayed for countering with a reply to this.
Okay.
Not,
Reply to this
Yes,
rejoinder.
yes, Your Lordship.
but my previous.
But they have not filed. It is
Yes.
now 2 years.
Yes. And my petition is pending since 2021, Your Lordship.
Your lordship.
And Your Lordship, it's crystal clear
1 or
here
2
as
days
per,
may-
as per para 9 of their reply.
You've got a copy now.
Just now I got your lordship, but kindly 1 or 2 days may be given so that I seek the.
No more adjournment, but day after tomorrow.
Your lordship,
Thursday.
your lordship.
Please also fix item in the admission column on Thursday.
Highly obliged.
Oblige your lordship.
Yes. So it's okay, but you called out the supplementary first. Yeah. Yes.
May it please your ladyship.
Yes.
Ladyship, there's a parted matter.
Yes. I'm telling him to call out the vote first.
From the supplementary cause list for hearing, item number 38.
Yes, Your Lordship.
Yes.
Lordship, yesterday, though I made a submission, I completely forgot to show a document. I'll take only 2 minutes. I have taken consent for a learned friend.
Okay.
Not to make submission, but just to point out the document.
Sure.
Lordship, with regard to entry in the service to the post of deputy manager, in my affidavit in opposition, respondent number 3, submission was made the other day, yesterday, but I forgot to point out, show the document, just to show that document only.
From the affidavit of
Yeah.
respondent 3.
Yes, my affidavit, yes. The page 166 is my appointment order, 16 of August 2012.
Yes.
Page 166 is my direct appointment order to the post of deputy manager, 16 of August 2012.
Appointment order.
Yes, which has been referred.
Mm.
Now at 168 is the upgradation and promotion of the private petitioner to the post of deputy manager, 16 August 2012. 168.
Page 168.
By this, she was upgraded to the post of,
Petitioner.
yes. Then the next page. She joined on 17/8/2012. This is the joining report of the petitioner. I made a categorical statement in my petition, in my affidavit, that I joined immediately on 16/8/2012 in terms of annexure 23, page 166.
And petitioner joined on 17.
17. In fact, in her representation, which was referred the other day, she was also pointing out that she joined later. The point only I'm making here is, yesterday I made a submission that in terms of the rules, direct recruit and promote is 60/40 for seniority. And second point is date of joining in terms of the rule.
Yes.
So since I belong to direct recruitment quota, that is 60%, and I joined earlier. So in the grade of deputy manager, since I'm a direct recruit, she's a promotee. Whichever way you look at it, I'm senior. Much obliged. It was submitted yesterday
Yes,
orally, but I
yes,
forgot
yes.
to show the document.
Your leadership, I have a stacked deck against me on the other side. Yesterday, from what I heard from both my learned friends, Your Lordship, I'm being shot at by a blunderbuss, Your Lordship. Blunderbuss, as Your Lordship is aware, Your Lordship, where the gun of old, where towards the muzzle, the barrel spreads out like that. You fill it with all projectiles that you have and then shoot, hoping that at least one projectile hits the target. So the first point I would like to make here, Your Lordship, is this. In reply, the first point I would like to make here. Much has been said. In fact, the beginning of the arguments of both my learned friends is that the NIDC is a corporation. It functions by administrative orders, administrative actions, and the plea that was sought to be projected is, by that kind of a submission, is that whatever actions the NIDC does, they are on the administrative side, they are not justiciable. They are not justiciable.
And that the rules are not under 309.
Yes, the rules are not under 309, therefore they are not justiciable. Though they do not say it directly, but that is basically the underlying point. Now, the fact of the matter is, both of them, from the very first instance, have not denied the fact. Firstly, the petitioner the respondent number 3, was appointed on an ad hoc basis and regularized its service. No denial. Secondly, your ladyship, now this is where they are at odds, where they are supporting each other. The respondent number 3 says that he applied as a fresh candidate and he was appointed as a fresh candidate. The state respondents, on the other hand, say no, he was not appointed as a fresh candidate. He was appointed as an in-service candidate directly by the DPC. So 2 points here first, your ladyship. The respondent number 3 says he was appointed as a fresh candidate. Wrong, a false statement. The respondents 1 and 2 say he was allowed to appear before the DPC as an in-service candidate. Your ladyship will find that statement here in the statement or in the affidavit of the respondent number 1 and 2. I've missed the page. Your ladyship, just give me some time with that particular page. This one, number 1. And your ladyship, this is the minutes of the BOD. At page 159. At page 159.
159 of
The affidavit of 1 and 2. Affidavit of 1 and 2. Yes, your lord. Yes, your lady. This is the minutes of the meeting and it's dated 17 July 2012. And your ladyship will also note the language of the circular with reference to your application dated July 17, 2012 for the post of deputy manager. You are hereby directed to attend the DPC.
Yes.
So the first one is a circular calling him for appearance before the DPC.
Yes.
This is not by the selection committee for direct recruitment.
This is by the DPC.
Yes. Why I am stressing on this point again, Your Ladyship, is that direct recruitment is by the selection committee in terms of the rules. Selection committee is set up by the board. It is not by the DPC. Your Lordship will recall the relevant provisions of the rules which we went through last time. This is not by the selection committee, this is by the DPC. And the recommendations of the DPC is at page 160. At page 160.
Yes, this one we've seen.
Yes. And Your Ladyship will see the relevant portion at page 161, at paragraph 4. Bottom 3 lines, Your Lordship, Your Ladyship, had allowed him as an in-service candidate, despite not having completed the minimum years of service.
It's an interim.
He did not have the minimum length of 7 years of service to be promoted from assistant manager to manager. Yet, the DPC allowed him to appear before it and made a recommendation for direct recruitment. So first and foremost, Your Ladyship, this is not by the selection committee. The DPC's recommendation is absolutely without jurisdiction. A document without jurisdiction, an order without jurisdiction is non-est in law, Your Ladyship. It can be challenged at any time.
But this DPC has upgraded your service also.
Yes, upgradation is a different thing, Your Ladyship.
Can the DPC upgrade?
The DPC can recommend upgradation. DPC can recommend upgradation. It is for the board to decide whether to accept that recommendation or not. DPC cannot recommend direct recruitment, Your Ladyship. There's a big difference there, night and day. And why is that, why is that, Your Ladyship? Again, if you may come to the rules, when DPCs are convened, I am using the same argument as my learned friend before respondent number 3 at Rule 29, Your Ladyship, at Rule 29.
The booklet has been
I can supply another.
misplaced. No, it's here also. It's next to the.
I can.
Respondent number 1 and 2.
Yes. This is clearer. Yeah. Just tell me the rule number.
Rule 29. Rule 29.
Yes.
Rule
Yes,
29.
yes. For promotion.
Yes. For all category of posts. For all category of posts. So the DPC is convened for all category of posts. And so in my category of posts, there was no promotional avenue. So the DPC recommended upgradation of the post. It is fully within the competence of the DPC to do so, Your Leadership. But the DPC does not have the jurisdiction or the power to recruit directly, Your Leadership. There's a big difference there. Now, much has been made by my learned friends about the Articles of Association of the NIDC. Yes. And they say that the NIDC is a profit-making body. So profit-making bodies are not subject to any rules or regulations. And profit-making bodies suggesting do not perform any public duties. Now, Your Ladyship, if Your Ladyship can come to the Articles of Association, there's a particular article which the respondents 1 and 2, as well as the private respondents, has just glossed over. Page 35. My lady can turn to page 35. All the previous paragraphs are well and good. But at B, at page 35, at B, the objects incidental and ancillary to the attainment to the main objects are 1, to promote and operate schemes for industrial development of Nagaland. In fact, this is not an ancillary objective. In fact, this is the main objective, Your Leadership, notwithstanding its placement in the Articles of Association. So the NIDC is a body which performs public duties. No doubt about that, Your Leadership. Its reason for existence is for developing industry in the state of Nagaland. And to say that such a body is not governed by any rules, to say that such a body can function as it pleases, that takes a little bit of stretching, your ladyship. And such stretching is not allowed as far as the rule of law is concerned. And additionally, something which the respondents have completely not placed before this honorable court is, they have referred to, my learned friend has referred to Rule 20, which says they will follow the rules insofar as retirement is concerned. But the main rule which they have not placed before this honorable court is this issue. Is the other copy. And this rule has been the subject of litigation before this honorable court on multiple occasions. And I'm sure your leadership is also aware of the rule, the litigation before this honorable court, insofar as the NIDC is also concerned. Many cases before the NIDC, originating from the NIDC, have also been decided by this honorable court in respect of these rules. NIDC is also covered by these rules. And Section 2. In this act, unless there is anything repugnant in the subject or context, public employment means appointment to any pensionable state public service or posts connected with the affairs of the state of Nagaland and the Nagaland Legislative Assembly, and includes any appointment under the government of India, any other state government, central or state public sector undertaking, and local authority held by persons prior to their absorption under the public service of the state of Nagaland and the Nagaland Legislative Assembly, which counts for the purpose of pension. This rule applies to the NIDC. These rules and the NIDC have been the subject matter of many cases before this honorable court. So to say that the NIDC as a business organization is not governed by any rules, they may call it administrative orders, is not governed by any rules, it is a fallacy, Your Lordship. And that is an argument which is liable to be rejected at the threshold. Then, your ladyship, the date on which the rules came into operation was stressed upon by the respondents 1 and 2.
Yes.
And if your ladyship would recall, there was a minutes of the BOD in the year 1990 which talked about a post of assistant manager legal, which was referred to by 1 and 2.
Yes.
So there was a post of assistant manager legal already in existence before the rules of 1991. Assistant manager legal.
Yes, it was there.
Now, your ladyship, come back to the rules again. Rule 2. Rule 2. Rule 2, applicability. Has your ladyship got that?
Yes.
Except otherwise specifically expressed or implied, these rules shall apply to all employees who are in the service of the corporation, except labor force, part-time, daily wages, contingent and work charge staff. Employees on deputation and on contract shall be subject to these rules, except to the extent to which they are modified by the terms and conditions of the deputation or special contracts governing their appointments. So there was a post of assistant manager legal when the rules were incorporated. In the year 1990, there was already a post of assistant manager legal. So in this context, your ladyship, in this context, If you come to the schedule to the rules, which is at page Annexure 1, the channel of promotion.
Page 97.
Yes. The first annexure, not Annexure 2. Annexure 2 contains the qualifications, but Annexure 1. Annexure 1. Now, your leadership will see assistant manager, etc., etc. These are just general streams. These are just general streams. There is no classification, there is no color as far as Schedule 1 is concerned, Annexure 1 is concerned. Now, in this context, now again, your leadership, if you can come to the mode of appointment, which you have already referred to, just the Rule 10. Rule 10. Rule 10. Direct appointment. Your leadership, there is only one way of appointment, direct appointment. Direct appointment to the services of the corporation shall be made as follows. The post of officers through Service Selection Committee, not by the DPC. Not by the DPC. Constituted for the purpose by the board. B, to any other post that is a subordinate post by the managing director. Now, your leadership will recall, yesterday, my letter friend for respondents 1 and 2 was referring to a decision of the board of directors, which said a committee will be constituted for the purpose of regularizing employees. That the board did not take any decision to regularize the respondent number 3. The only decision taken was that a committee will be constituted in terms of the guidelines issued by the government to take up cases for regularization. And the respondents 1 and 2 say, I have not challenged that. Where is the necessity? No one was regularized person in that decision at that point of time. The board did not say we are going to regularize the service of respondent number 3. Even otherwise, your leadership, look at all the orders. Like for instance, should be this one number 3. Page? Yeah. Okay. Page? 147A. Exactly. No. What is page 47? Your leadership, can you turn to page 47? This is the order by which he was appointed as the
47 of.
yes, assistant manager to of my petition.
Appointment order.
At page 47. Has the leadership got that?
The appointment order of the respondent.
Yes, to deputy manager. Now, Look at the language of the order, Your Ladyship. In the interest of the corporation, as approved by the Board of Directors. Now, why am I mentioning this? As approved by the Board of Directors. Now, this order has no independent existence from the decision of the Board of Directors. And the decision of the Board of Directors merges into this order. So actually, Your Ladyship, there is no necessity of challenging any decision of the Board of Directors. The effect, the decision of the Board of Directors merges into the order. So in all the orders which I have impugned, all the orders are in similar manner, worded in similar manner. From deputy manager to manager to DGM to GM. If the decision of the Board of Directors had not been mentioned, Your Ladyship, possibly an argument that they have raised could have held some substance. But in each of the orders, it is mentioned that it is pursuant to the decision of the Board of Directors. So the decision of the Board of Directors merges in the actual order, the action taken on the decision of the Board of Directors. So there is no need to actually challenge the decision of the Board of Directors. It is just a duplication. And the first order, Your Ladyship, this is important. The first order is at page 46. This is important because this is the basis of his entry to service. Page 46. And his subsequent promotion, his subsequent so-called direct recruitment is on the basis of this order as an in-service candidate. Now, what does this say, Your Ladyship? This is dated 23/3/2010. 23/3/2010. In the interest of the corporation, the ad hoc Shri Timjin Yangar Jami is hereby regularized to the post of assistant manager with effect from 24/2010 in the scale of pay such and such, plus all other allowances as are admissible from time to time. Shri Timjin Jami will be on probation for a period of blank years, which is extendable subject to the performance of the employee and service confirmation. She shall be further subject to satisfactory performance of the employee. He shall be entitled to join CPF, etc., etc. In this case, here, there is no mention of any decision of the Board of Directors in this order. And subsequent to his appointment to the post of deputy manager, page 47A, Your Ladyship, page 47A. Is the Ladyship page 47A? This is again a very important document. This shows the manner in which the respondent number 3 has been brought into the department, and all these facts have been glossed over by respondents 1 and 2. This is dated 4th September 2012. Subsequent to the direct appointment, kindly know the language, Your Ladyship, of Shri Timjin Yangar to the post of deputy manager, of Timjin Yangar Jami assistant manager to the post of deputy manager. Look at the language, Your Ladyship. As a departmental candidate and pursuant to Government of Nagaland PNAR memorandum dated 1/3/18/2012, the service rendered by him as assistant manager with effect from 7 February 2009 till 15 August 2012 shall be counted for computation of public service, of public employment under the Retirement Act. He was already in regular employment as assistant manager, Your Ladyship. This is not someone who was an ad hoc service and then subsequently regularized as deputy manager. He was already in regular employment as assistant manager. As an in-service candidate, the EPC appointed him directly. This is the point, Your Ladyship. So therefore, the basis is the order, the first order at page 46. The order which brings him, which purports to bring him into the service of the corporation. If this order goes, if this basis goes, the entire edifice goes as far as the respondent number 3's appointment is concerned. He could not have been regularized in service. The only way of entering into service is by direct recruitment, not by regularization. That is the rule. That is what the rule says, Your Ladyship. Next, Your Ladyship, the 2001 decision of restructuring or cadre review, which is in R1 and 2's affidavit. No, 1 and 2. Very good. What page number is it? What page number is it? Which one last? I'm so beautiful. It's difficult to remember the pages in 132. 131. Publish it over. It has taken ridiculous notes. It's okay. She has forgotten. Where is she forgotten? Yesterday she was very good. So she has written the notes. Okay. May I please your,
Yes.
my lady, my learned friend, the documents that he is referring, in fact, during his submission, he had referred all these documents in detail. So my respectful submission is in those areas where he would like to give his rejoinder clarification. If we confine to that, that would be better. Otherwise, the petition will never end.
No. Your Ladyship, if your Ladyship recall, I did not refer to any documents.
These are not referred actually.
Yes. I just mentioned the election numbers. I did not actually refer to them. In fact, it was the counsel for 1 and 2 who referred to all of them in detail. But somehow there has been a misrepresentation on their part. So I'm trying to clarify, Your Ladyship. Now, this is at page 131. This is the first sort of restructuring exercise which was undertaken in the year 2001. In the year 2000.
131 of respondent 1 and 2.
1 and 2, yes, Your Ladyship. 2001.
Yes.
This was 24 July 2001. Page 131,
Yes.
the heading. Now come straight to page 137, Your Ladyship, the recommended promotional channel. Recommended promotion channel. Has Your Ladyship got that?
Yes.
Now,
Yes, we
One
have
thing-
seen this.
Yes, one thing first, Your Ladyship. So the post of manager legal is already there. Post of manager legal is already there. The second point which Your Ladyship will note, there are different streams. I will not even call them cadres. And there's a reason why I'm saying that, Your Ladyship. Different streams. So the LDA stream, the steno stream, section officer, etc., ministerial service, then legal service, and management service. Just different streams. And why I am saying this, Your Ladyship, is that there was always one seniority list. There was always one seniority list. There was never different seniority list for so-called different cadres, which the respondents are not trying to place before Your Ladyship.
That they've also admitted.
Yes. But they are saying it was a mistake. It was not a mistake. It was not a mistake. Respondent number 3 is claiming it was a mistake. Respondent number 1 and 2, in respect of the seniority list of 2021, where the respondent number 3 was placed ahead of me, in their affidavit, now they're saying it's a mistake. But the fact of the matter is, all along, there was just one seniority list. All along, even after 2016. Again, the respondent number 3 was the other day, Your Ladyship, yesterday, the respondent number 3 was
They
saying,
mean mistake in placing the respondent 3, you senior of respondent 3.
yes, that's what they're saying. So that the correction of the seniority list was a mistake. That's what they're saying. The respondent number 3 was initially placed ahead of me. I submitted a representation that was corrected.
Then you were placed senior.
Yes, I was placed senior to respondent number 3. The 1 and 2 are now saying that was a mistake. In their affidavit, they are saying that was a mistake. That so-called mistake has not been corrected till date. The seniority list of the year 2016, the combined seniority list, there was no separate seniority list for different cadres, which the respondents 1, 2, and 3 are now claiming. Even after 2016, and Your Ladyship will find the seniority list in paragraph 5 of my writ petition. Even after 2016, seniority lists were issued, and all the seniority lists until 2023, that is the seniority list which I am impugning in this petition, I was senior to the respondent number 3. Until 2023, as I was urging last time, Your Ladyship, I had no occasion to question the service of the respondent number 3. In all my representations, I did not want to disturb his service. And much is being made of the fact that I was asking only for my seniority in my representation. Yes, let him continue his service if that's what they want, as long as he's not senior to me. But that cannot be used as the ground against me to say that my petition is bad because my representation says something else and the prayer that I'm asking for in my petition speaks of something else. That's totally absurd, Your Ladyship. Totally absurd. I am saying someone who has brought into service because the rules should not affect my service. That is the context of my representations all these years. And that context has been appreciated by none other than 1 and 2 until 2023. Now, the other point taken now, Your Ladyship, is that both at 1, 2, and 3, both 1, 2, and 3 are saying that I do not have any locus standi. Their own actions, that is a self-defeating argument. Their own actions nullify that argument. And how is it nullified, Your Ladyship? The seniority list till 2023. It is a single seniority list. It is not a seniority list on the basis of color. And in order seniority list, I am senior, except for 23. The other ground that is being taken is now the so-called alternative remedy under Rule 4. This is worse than, in fact, Your Ladyship, this is worse than an appeal from Caesar's wife to Caesar or vice versa. This is an appeal from Caesar to Caesar himself. Empty formality. It is of no consequence. It is just an empty formality. And it is just an argument which is being taken to frustrate my case. And not only that, Your Ladyship, All orders, except for the first order, all orders are passed by the Board of Directors. Another interesting argument which has been taken by the respondents 1 and 2, Your Ladyship, and this is with regard to the previous case, at page 195 of the respondents 1 and 2 affidavit, Your Ladyship, this last page. Last page, at page 195.
Acha, yes.
Yes, at page
Earlier
195.
case.
Yes, the board, if Your Ladyship can come to the 1, 2, 3, 4th paragraph. The board further observed that the management had misinterpreted the recommendation of the DPC, which had indicated the individual marks. Can you note this, Your Ladyship, which had indicated the individual marks? This is important. Scored by the eligible incumbents and had taken the marks scored to determine seniority, which was in contravention of established norms. Moreover, both were promoted on the same date, and accordingly, Mr. Imsu, being senior, retains seniority. Two things here, Your Ladyship. Marks, they were assessed on the basis of marks. And the board decided on what was the principle to be adopted for seniority. Board promoted on the same day, therefore, Imsu remains senior because he was senior. And what does 1 and 2 say now? This principle does not apply to me because this is from the management cadre. And I am in the legal cadre. Do we have a separate set of rules? We have just one set of rules, Your Ladyship. How can they deviate from their own principles which they follow? And to say that that is not applicable to me. And insofar as the decisions of the board are concerned, Your Ladyship, just one more. And that is that the decision of 2016. 2016. Page 52, Your Ladyship, of the writ petition. 19 September 2016, 15 June, effective from 15 June 2017. Again, Your Ladyship, the different categories of posts. The streams, I will not call them, again, Your Ladyship, I will not call them cadres. The different streams under the NIDC. And of course, finally, the meeting point, the convergence at page 54. Again, Your Ladyship, even notwithstanding 2016, the other day, a statement was made that after 2016, separate seniority lists were maintained. Then, not true. Single seniority list. Even the 23 seniority list is a single seniority list. It is not a seniority list on the basis of so-called cadres which respondents 1, 2, and 3 are urging. Yes, a single seniority list. That is why, Your Ladyship, I am using the word different streams. I'm not even using wings, Your Ladyship. Different streams in the service of the NIDC. Seniority list, just one. The third argument which was raised by both sides, Leadership, settled issues. Settled issues.
Settled issues cannot be unsettled.
Yes. Settled issues were the issues settled up to the year 2023. Who settled issues? It is not me, Your Ladyship. It is 1, 2, and 3 who settled unsettled issues. Who unsettled settled issues. And so the authorities that they have relied upon insofar as unsettling settled issues is concerned, should be applied to them with extreme vigor, Your Ladyship. It is not me who has settled issues. It is they who have settled issues. And they are saying they are using the ground of delay also, Your Ladyship.
Delay, yes.
Yes. Where is the delay? I came to the court as soon as settled issues were unsettled in the year 2023.
Delay in the sense of his first direct appointment.
Yes, Your Ladyship. So I had to challenge that because unsettled issues were settled. Settled issues were unsettled in the year 2023. I had to go back to his entry into service. And I had no occasion to go back into his entry into service prior to 2023. So where is the question of delay? And the other ground taken, Your Ladyship, is DPC is an expert body and its findings cannot be varied by this Honorable Court in the exercise of its writ jurisdiction. Come back again, Your Ladyship, to page number 190, the last page of the affidavit of 1 and 2. 1 and 2. At page 195. The same paragraph. How did the DPC decide between these two persons? They evaluated them. They gave them marks. Your Ladyship may kindly note, they evaluated them, they gave them marks. And on the basis of marks, one of them was considered more meritorious. And the DPC accordingly fixed his seniority above his senior. But the board said, no, it is not your business to fix seniority. He may have been more meritorious, but they have been promoted on the same day. And since Imsu Jamil was senior, he continues to be senior. The only excuse, as I was saying earlier, Your Ladyship, is that this is from the management cadre, therefore it does not apply to me. Then the most interesting argument that I have heard, Your Ladyship, is from my another friend representing the respondent number 3. And an attempt has been made to distinguish the exercise of authority under Rule 28 and 29. That is a fallacious argument, Your Ladyship. The DPC determines who is fit for promotion. In the decision, in deciding who is fit for promotion, certain parameters are taken into account. In the process, someone benefits and someone loses. That's the first point I'm trying to make in relation to Rule 28 and 29, Your Ladyship. Is the DPC supposed to mention any rules? First point I would like to make, Your Ladyship. Is the DPC supposed to mention any rules? The DPC is not meant to mention any rules. DPC is just to assess.
No,
to
Rule
assess.
29 was brought in to
Yes.
show that it is merit come seniority.
Yes.
And not seniority come merit.
That's all right. But the argument that was advanced is that Rule 28 has not been brought into operation, and I have made no mention about Rule 28. Where is the necessity? Rule 28 and 29 go hand in hand. They are inseparable. I have not made any statement in the petition saying that Rule 29 has been violated, Rule 28 has been violated. Is it necessary, Your Ladyship? I am saying that the recommendations of the DPC are illegal, and that encompasses both Rule 28 and Rule 29, because Rule 28 and Rule 29 go hand in hand. They are inseparable. One cannot exist without the other. And there was no necessity for a DPC to mention any rules. And that cannot be a handle for the respondent number 3 to say that Rule 29 provides him a safeguard. May I read Rule 28 once, Your Ladyship? Seniority of persons appointed to a grade shall be determined in a class of posts to which they are appointed by the date of joining of their posts. The interstate seniority of the persons promoted from lower grade, promotion, your ladyship, shall be maintained in higher grade as well, except in the case of supersession. Interstate seniority between direct recruits and departmental promotions appointed on the same day in a particular post shall be 60% and 40%. Now, very conveniently, this one number 3 wants to rely only on the second portion of Rule 28, 60%, 40%. Direct recruit being given precedence over departmental promotions if such situation arises. Now, what does supersession entail? Your Ladyship, if I may pause here for a moment, because I want to counter even the argument of the state that multiple persons were considered, 2 persons were considered, and therefore merit was assessed between the 2 of them. Now, the point here is, on the face of it, it looks like a very attractive argument, Your Ladyship. But there are 2 posts, and what is the standard? What is the procedure for promotion? Though the rules are deficient, these are general rules. These are general standards, Your Ladyship. 1 post, there is zone of consideration. 2 posts, there is a zone of consideration. If you club posts together, there are zones of consideration. And from those who are in the zones of consideration, merit is assessed. In the instant case, Your Ladyship, there are 2 posts. There was no zone of consideration. There were only 2 candidates. How could you assess merit when 2 persons competed for 2 posts? For each post, there is a zone of consideration. And within that zone of consideration, you assess merit. Ex facie illegal, Your Ladyship. Ex facie arbitrary. Ex facie arbitrary. The other point, as far as the DPC is concerned, Your Ladyship, is that I must implead the members of the DPC by name if I'm alleging mala fide. That is again an argument which is rather far-stretched, Your Ladyship. I am challenging the minutes. I am challenging the actions of the DPC. In all the years that I have been practicing, Your Ladyship, and I'm sure Your Ladyship too, I have not seen a single case where if the decisions of the DPC are challenged, you make every member of the DPC a party. So that is a very hollow argument, Your Ladyship. And that is also an argument which needs to be outrightly rejected. Now, Your Ladyship, again, another point as far as this is concerned, I am from of course, the zone of consideration. That is one point. The other point is this: the convergence is in the grade of DGM. The conversion is in the grade of DGM. The conversion is in the grade of DGM, and from DGM onwards, 1 promotion each channel. 1 promotion each channel. Going by Rule 28 and 29. Going by Rule 28 and 29. If any promotions are to be considered, Your Ladyship, 28 and 29 must be read together. There can be no gainsaying that, no matter the protestations of the private respondent number 3. 28 and 29 must be read together. Rule 28 is a rule which provides for supersession. Rule 29, let me turn it around in the same language as my learned friend. Rule 29 does not provide for supersession. It just says merit cum seniority. But Rule 28 provides for supersession. Reading it together with merit cum seniority, there is an implicit requirement for furnishing reasons. In fact, an express requirement for furnishing reasons if someone is to be superseded. Rule 28 and 29 require that reasons are to be provided if there is a case of supersession. Apart from the fact that supersession doesn't lie because you have two different posts, your leadership, the first point, keep that in mind. Accepting their ground, accepting their argument. Reasons must be provided. How will you supersede your leadership? Can you just say that you're senior, you're junior, but I'm going to promote you? Would that be acceptable, your leadership? In this day and age, when our jurisprudence has grown to such a high level, is that an acceptable argument, your leadership? It is not. So Rule 28 and 29 get together, stipulate that when someone is to be superseded on the principle of merit cum seniority, you have to provide reasons. Supersession can only come about, your leadership, if you provide reasons. Without reasoning, there can be no supersession. If you're assessing merit and suitability and you're assessing someone to be more meritorious, there must be reasons. So therefore, the DPC, when it recommends, can it be just a stock statement? A stock statement, dear leadership, I'm referring to the plain language of relying upon the plain practice, rather, your leadership, the plain practice of relying upon the language of the rules. Just that much, a stock statement, quoting the language of the rules and saying that on that basis, X is more meritorious than Y. Is that permissible in law? That is not permissible in law. So 28 and 29 must be read together, your leadership. And if there's any case of supersession, it must be based on reasons.
I think you have covered everything.
Yes, your lordship. Yes, your leadership. Just the authorities now. Just the authorities. I have expanded a little bit on the authorities, your leadership. Just to cover the points raised by the other side. Can I revise the earlier list of authorities? Can I take that back, your leadership, and furnish a new one?
Okay. Was it supplied? Just check. On your list. This is our one and two. This one.
Yes, your leadership. Let me see, let me compare.
Sure.
No. That's the early one. The new one. It's a new one. New one, I've given this one. This is a new one, your leadership. I've revised it, your leadership.
Okay.
Can we quickly go through it, your leadership? Yes, quickly go through it. The first one was Uma Devi. Unless the appointment is in terms of relevant rules and after a proper competition amongst qualified persons, the same will not confer right on any appointee. All judgment and orders contrary to the directions issued shall be denuded of their status as precedents. So this is 2006, your leadership. 2006. If orders of courts are denuded of their status as precedents, where does the instructions issued by government stand? Then 2006 is national fertilizers. Now, this is with regard to a corporation, in addition. A state, the NIDC is a state within the meaning of Article 12. Your leadership may kindly note that. The NIDC is a state within the meaning of Article 12. The National Fertilizers Limited is also a state within the meaning of Article 12. State within the meaning of Article 12 of the Constitution is bound to comply with the constitutional requirements as adumbrated in Articles 14 and 16 thereof. Regularization is not a mode of appointment. Even in corporations, appointments without following rules are a nullity. The state does not enjoy the power to make appointments through executive actions. Appointments made on the basis of applications submitted are illegal. Same thing here, your leadership. Recruitment rules ignored and selection committee not properly constituted point to illegality in the appointments. Here, not by the selection committee, but by the DPC. Long years of service, no protection. long years of service is no protection. The ground of delay, Your Ladyship. 3 is 2018 Management Assistant Salt Commissioner versus Secretary Central Missouri. When a statutory action is performed, it must be done in the manner laid down under the rules. 4 corners, Your Ladyship. The 4th one, UPSC versus Jantalal. Any regular appointment to a post under the state without issuing an advertisement and issuing application and inviting applications from eligible candidates and without holding a proper selection where all eligible candidates get a fair chance to compete violates the guarantee under Article 16. The next one, long years of service, no protection for an appointment made in violation of the rules. Here it's about 2 decades of service. In this case, Your Ladyship. And seniority. Those appointed, this is Rafiq Uddin, Your Ladyship. This is the first case which distinguished between, not to say first case, but one of the leading cases which distinguished between those who are regularized in service and those who are regular employees and how they are to be treated. Those appointed irregularly belong to a different stream and they cannot claim seniority vis-a-vis those regularly appointed and properly appointed. Persons appointed to the service in violation of the rules form a separate class. Those not appointed in accordance with rules cannot claim seniority over those who have been appointed in accordance with the rules, having put in many years of service, in this case about 12 years, without striking down their appointment, they will be placed below the candidates selected in accordance with the rules. So here the Supreme Court laid down, Your Ladyship, that it may not be necessary to strike down their appointments, but they will be placed below regular appointees. So much has been made about me not challenging the basic orders, not necessarily also actually, in fact, in terms of the law laid down by the Honorable Supreme Court. It is not necessary to strike down their appointments. They can be placed below regular appointees. The next one, this is important. This is interesting, Your Ladyship. This is 2 cases which are connected. 1992, 1 SSC, and 2008, 15 SSC. Now, prior to the first citation, 1992, 1 SSC, Your Ladyship, prior to this case, in the same case, some group of doctors, ad hoc appointees, they came to the Honorable Supreme Court seeking regularization. And the law, as it was at that point of time, the Honorable Supreme Court directed that these persons be regularized in service. So, regular doctors came to the Honorable Supreme Court, and they filed a petition saying that their services should not be prejudiced by regularization, regular service by the regularized doctors. And these were the directions that were issued. And it finally came to be settled in 2008. Your Ladyship, 1992, first case prior to 1992, it finally came to be settled in 2008 in a contempt petition seeking to enforce the directions earlier passed. So in 1992, 1 SEC, the Honorable Supreme Court, considering its earlier directions to regularize ad hoc appointees, took into consideration the prayer of regular doctors that their services should not be prejudiced. The regularized doctors were directed to be treated as a separate category with their own seniority list and the creation of an appropriate number of supernumerary posts. The Honorable Supreme Court in paragraph 3 held that there should be no prejudice to the doctors appointed through regular appointment based on the proposals submitted which would safeguard their interest and not prejudice the regular appointees. At paragraph 4, directions were issued inter alia that in order to ensure that there is no disturbance to the seniority and promotional aspects of the regular doctors, there will be a separate seniority list of the regularized doctors. Clear directions in leadership. Then the matter again came up before the Supreme Court in 2008, 15 SEC in a contempt petition. In this petition, considering paragraph 4 in 1992, 1 SEC, the Honorable Supreme Court at paragraph 12 clarified that the promotion of a regularized appointee will only be to supernumerary posts, and that if one regular appointee was promoted, a senior from those regularized whose date of initial appointment was earlier to that of the said promoted regular appointee was to be promoted to a supernumerary post. This is the adjustment that was made, Your Ladyship. Respondent number 3 has not been appointed in accordance with the rules. Therefore, he can only be appointed to a supernumerary post and he cannot be made senior to the petitioner. He belongs to a different stream and cannot claim seniority vis-a-vis the petitioner who was regularly appointed. 3, 2008 supplementary. This is by a division bench in our leadership of our Honorable Court. And this relies on the Rafiq Uddin case. And this is also a case from Nagaland. After the decision of the Constitution Bench in Secretary, State of Karnataka versus Uma Devi, the sustainability or otherwise of public employment has been reviewed in the light of the constitutional scheme of public employment. Appointments can be made only in accordance with the recruitment rules No order, notification, or circular can be substituted for statutory law. It is the bounden duty of the court to ensure that the beneficiary of an illegal appointment or an illegal promotion does not steal a march over the regular appointee. An irregular appointee cannot be placed senior to a regular appointee. When the appointment of a government employee is found to be irregular, the court, having regard to the long period of service which the irregular appointee might have put in, may not set aside the appointment, yet it shall ordinarily make him rank junior to the regular appointee, particularly when the regular and irregular appointees had not come to be selected through the same selection process. Then 4 is Nitoli, again, on the same principle, Your Ladyship, on the same principle. Not necessary to set aside, but he will be placed junior. Then Rubul Sharma, Your Ladyship, this is also again relying on Rafiquddin. And this is 2023, a very recent judgment, Your Ladyship, on the same principle. Then at C, principles of the exercise of authority. Then in this one, what I was referring to about Rule 28 and 29, Your Ladyship will recall, they have to be read together. And supersession, merit cum, seniority, reasons must be assigned. When the rules prescribe a mandatory duty to record reasons for proposed supersession, resorting to a rubber stamp reason given mechanically justifying the supersession does not amount to reasons as contemplated by the rules. The stock reason, and this is precisely what I'm saying, Your Ladyship, the stock reason in the minutes of the DPC, just the language of the rule has been copied, nothing else. Nothing else, with little variation. The stock reason is a general description of the process adopted in arriving at a conclusion. The minutes of 2023 is just a stock description of the process. It doesn't say how merit has been assessed. It is incumbent upon the selection committee to state reasons in a manner which discloses how the records of one officer superseded stood in relation to records of another who was preferred. This is a visible safeguard against possible injustice and arbitrary selection. Reasons are the links between materials on which certain conclusions are based and the actual conclusions. They disclose how the mind is applied to the subject matter for decision. They should reveal facts considered and conclusions reached. Only in this way, the opinions and decisions recorded can be manifestly just. It is not enough to say that preference should be given because a certain kind of process was gone through. Exactly what has happened in our case. In the case at hand, the DPC merely records the process and gives no reason. The facts are similar to the case decided by the Honorable Supreme Court in the above referred case. In paragraph 30, the order of supersession was quashed. No reasons were assigned. The order of supersession was quashed. Your Ladyship will kindly note the minutes of the Departmental Proceeding Committee merged with the order of supersession. The order of supersession was quashed. It is not as if the DPC was quashed. Minutes of the DPC was quashed. The order of supersession was quashed. That is, in fact, Your Ladyship, a general principle of law. Orders, the process merges into the final order. But now, because of the decisions, the slew of decisions about not challenging the basic order, this complication is set in. Otherwise, Your Ladyship, the deliberations of the DPC merge in the order which is issued. The deliberations of the decisions of the Board of Directors merge in the order which is passed around. Then 2, this is the ML Kapoor, this refers to the previous case, Your Ladyship. The ML Kapoor case, Supra, was by a two-bench judge of the Honorable Supreme Court. In this case, the judgment was by a three-bench judge. The bench of the Honorable Supreme Court quoted and followed the decision of the ML Kapoor case. Then, this is important now, Your Ladyship. An order passed by the statutory authority must be judged on the basis of the contents thereof and not as explained in the affidavit. Why I am saying this is important, Your Ladyship, is both the state respondents as well as the private respondents, they say, I have no locus standi. In fact, that is the strongest ground taken by them. I have no locus standi. That is the stand taken in the affidavit. But what do the actions show? What do the actions show? All along, our services were clubbed together. All along, our services were clubbed together. And there was just one seniority list. There was just one seniority list. So therefore, to say that since the respondent number 3 belongs to a different stream, I cannot question his appointment, that is wrong. The records, the orders do not justify that. Then 4, the validity of the order impugned has to be tested on the basis of the reasoning contained therein, and that the authorities are not supposed to supplement the same by means of extraneous material or affidavit before the court. Same principle, Your Ladyship. Then 5, recommendations of the DPC are advisory and not binding on the authority. Now, in this case, Your Ladyship, the paragraph is mentioned, paragraph 17 is a short paragraph. The competent authority deferred with the opinion of the DPC. Someone took umbrage at that. And the Honorable Supreme Court said, no, it is fully within the competence of the authority. They can defer with the recommendations of the DPC. So meaning thereby also, which supplements the argument that I'm making, the recommendations of the DPC merge in the order which emerges from that. So there is no necessity at all to challenge the minutes of the DPC. But I have done it as far as 23 is concerned. As far as 23 is concerned. Now, another ground which the private respondent has taken, and again, to me, it is an attempt at just grasping at straws. I have to mention in my petition that I am more meritorious than the respondent number 3. And I have not made a single statement in my petition that I am more meritorious than this one. Is it necessary, Your Ladyship? Am I to judge my own merit? It is for a DPC to decide who is more meritorious. Do I have to make such a statement in my petition? The respondent number 3, on the other hand, Your Ladyship, the respondent number 3 has access to all the records which are not available to me. And he says that he has got all the ACRs, including mine, and therefore, according to the ACRs, he is more meritorious. All these, the stand taken by respondents 1 and 2, the arguments advanced, the information available with them, does it not point to just one fact, Your Ladyship? That there is a concerted effort to make the respondent number 3 senior to me. And in doing so, they have no hesitation at all about violating the rules.
Regarding the point of not challenging the basis,
Yes, Your Ladyship.
even if the appointment and promotion orders are quashed, the recommendation still remains then?
Which one, Your
The
Ladyship?
recommendation recommending the promotion or appointment
No.
of the respondent 3
No, Your Ladyship, if the
by
foundation,
the board,
yes, Your Ladyship,
that's
if
the
the,
foundation.
if the foundation goes, everything goes. If the first appointment goes, everything goes. Everything is built upon the first initial appointments, Your Ladyship. That is again a settled principle of law, Your Ladyship. If the basis goes, all consequential action go. If the initial action, which is impugned, goes, all subsequent actions automatically go. They have no foundation. So I am challenging his regularization in service. I am challenging his promotion, his direct recruitment, to the post of deputy manager
Yeah, that of course.
as an in-service candidate. Now, Your Ladyship, just one more point. Union Public Service Examinations. Union Public Service Examination. You challenge someone's appointment order. You challenge someone's appointment. You challenge the order itself, because the appointment order is the culmination of the entire process. You challenge the end product. You don't have to make the challenge right from the inception, Your Ladyship. In all the orders which I have impugned, Your Ladyship, the reference is there to the decision of the Board of Directors. It derives from the decision of the Board of Directors. So it is the culmination which is challenging. The entire process doesn't have to be challenged, Your Ladyship. And just for your Ladyship's satisfaction, in my the respondent 1 and 2, the minutes, the minutes of the DPC, page 183. Page 183, at page 184. It is there in my affidavit, in my writ petition too, but since I'm with the affidavit of 1 and 2, at page 183.
183.
Yes, this is the minutes of 10th March 2023. 184. Second paragraph, Your Ladyship. That as per the assessment of the APR and performance of the officers in the interview, the committee also an examination of all available records of the officers in line for promotion had considered and recommended the following cases. Where is the reasoning? It is just a description of the process. This is what I was relying upon, Your Ladyship, in the authorities that I relied on. This is just a description of the process. Again, Your Ladyship, at the cost of repetition, first and foremost, there was no need to assess relative merit because we were considered against two different posts. And merit would have been necessary if there were many candidates and there was a zone of consideration for each of the posts. In our case, there was no zone of consideration. Each of us was considered independently against the two posts. And again, Your Ladyship, forgive me for stressing this point again. The respondents 1 and 2, as well as 3, say there's no need for recording reasons. But 28 and 29 implicitly, in fact, expressly require the reasons to be assigned. And 195, again, Your Ladyship, 195 specifically shows that the DPC assigns marks. There is a process of evaluating and marks are assigned, and on the basis of marks, merit is assessed at page 185. In our case, it did not happen. It was just a description of the process. Nothing more. Well, there's another ground which was taken by the respondents that the state can alter seniority. But seniority must be on some principles. It cannot be at random, Your Ladyship. Yes.
Who gave this?
Yes. So it's about two persons who were promoted in the same day. Yes. Two persons who were promoted on the same day. Two persons promoted on the same day. Therefore, the elder amongst them will be the senior. This is by a division bench, Your Ladyship. Then there's a recent decision of our Honorable Court, Your Ladyship. This is again a division bench. Again by a division bench. And this is about whether it is necessary to challenge, to impugn the minutes of the DPC. This is a division bench matter, Your Ladyship, and not going into too much of the details. If Your Ladyship can come straight away to paragraph 10. Paragraph 10. The batch of writ petitions filed by the appellants have been dismissed or not being maintainable on the ground that the minutes of DPC has not been challenged and only the consequential orders have been challenged. The learned single judge also held that the challenge has been made belatedly and is also held by the principle of non-joinder of necessary parties. However, the challenge to the promotion of 1D Suresh by the impugned order dated 2014 has been sustained and set aside, thereby partly allowed the writ petition of appellant Prasanta Gura. Thus, we find the writ petitions have been dismissed and rejected basically on technical grounds. So this was what was before the Honorable Division Bench. Then, if you can come to paragraph 28. Paragraph 28. Here also, Your Ladyship, this was the grounds taken, defense taken was delay, etc., etc. 28. Reverting back to the present case, it is apparent that the seniority has been fixed on the basis of the roster point seniority, which was taken for purpose of promotion while calculating the number of vacancies backlogged by clubbing the vacancies of all the years when the DPC was held, which resulted in deprivation of the appellants. We find that the entire actions of the respondent authorities in conducting the DPC by clubbing the vacancies of all the previous years and the current year without adherence to the rules and guidelines is illegal, as such not sustainable. The respondent authorities have failed to adhere to the relevant rules, guidelines regulating the procedure for promotion issued by office memorandum in conducting the DPC and its consequent promotion orders by clubbing all the vacancies of previous years and the current year, thereby placing the reserved category candidates en bloc above the general category candidates. Thus, in our view, such action is not sustainable. 29. In view of what has been discussed above, we find that the dismissal of the writ petitions on the grounds of non-challenge of the DPC minutes and non-joinder of necessary party, as well as on delay and lashes by the learned single judge, is not sustainable. And accordingly, the impugned judgment in order dated 23/3/2021, passed by the learned single judge, is interfered with and is set aside, except the setting aside of the promotion order of one person. So the rules have been violated. So when rules have been violated, it's not necessary that you challenge the minutes of the DPC also. Just the consequential orders. Just the consequential orders can be challenged. In similar manner, Your Ladyship, the minutes of the Board of Directors also. It merges in the consequential orders. May I rest, Your Ladyship?
Just 2 points, Your Lordship. Now, insofar as the services of the private respondent or be it the petitioner, whether they amount to public employment, now there is not an issue insofar as this petition is concerned. But since the petitioner has raised that in view of Rule 20 of the service rule, that they will be governed by the Act. Now, in this regard, may I state that none of the officers or staffs of the NIDC, they enjoy pension from the state government. And Rule 42 of the service rules, we are governed by the EPF scheme or the EPF Act. Now, secondly, on this ground, we have a decision of the division bench, if of just 2021-3 GAULR 238, where it specifically provides, or the court has specifically held that in order to be a public employment, the essence is that it should yield pensionary benefits at paragraph 13 and 14. I just want to clarify that position. Secondly, 2021 3 GAULR Gauhati Law Reports, page 238 at paragraph 13 and 14. Secondly, the petitioner is not again challenging Rule 29. Therefore, this court ought not to enter into the validity of Rule 29 as to how Rule 29 should operate, whether there should be whether reasons should be recorded, how the merits should be assessed, and all those questions. This court is not competent to enter without the challenge to the virus of Rule 29, which the petitioner has not done in this case. And finally, I would like to reiterate the paragraphs, the paragraph 40 of my affidavit, paragraph 40 of my affidavit, where I've stated that Rule 28, the second part of Rule 28 will be subservient to Rule 29. Because if the seniority is given to be, if seniority is to be given weightage, that will do violence to Rule 29. That will render Rule 29 redundant. When on the other hand, Rule 29 specifically provides that all category of posts, meaning that all category of posts are selection posts. Therefore, there has to be relative assessment of the merits, regardless of the position of seniority. At paragraph 40, I stated in
only at that, only at that point of public employment, only at that point. Now, Your Ladyship, we have the Nagaland Retirement Act, and it applies to corporations. It is not because of Rule 20. It is no. There is a misleading point.
That has been adopted by the corporation, not imposed by the state government. So that has to be the other way.
No.
You
They're
cannot.
saying that they're governed by EPF.
Yes.
Yes.
They are not pensionable.
So corporations can have that. But where does, for the purposes of the Retirement Act, where does that Where does that remove the color of the public employment for them? Because you see, in addition, when arguments were in the NIDC cases, the definition of public employment was sought to be pressed into service.
This 2021 GLR is specifically for NIDC or corporation.
generally.
Corporation.
Yes.
Oh, acha, acha, acha.
Definition of public employment.
Ah,
So for our purposes, even corporation service was taken to be public employment. According to our statute, the Retirement Act, distinction there, Your Leadership. There's a big distinction there.
Lordship, in some corporation in Nagaland, for example, Gauhati, there, the Lordship, I have done cases here. Their rules provides, like the NIT's rule, retirement at age of 60. They have decided not to follow the Public Employment Act. So in the present case, it is not the case the government is imposing it. It is within the discretion and domain because it is, Lordship, not. So accordingly, they have only adopted. Adopting a rule does not mean that imposing all the issues, implications of that particular rule. That has to be distinguished.
Adopted, but maybe the language in Rule 26 specifies that they decided to borrow that.
Borrow, yes. Yes, that will follow the principle. Yes, it is. Kindly properly examine the Rule 20. And Lordship, just a reminder, my application for fresh for deputy managers of fresh candidate is at page 156. My application is at page 156 of respondent number 3 affidavit. So Lordship, may kindly properly examine that because a submission has been made that page 156, my application for the post of deputy manager as a fresh candidate. Page 156 of affidavit in the position of 1 and 2.
You should just a clarification. Just a clarification. Because my learned friend is making his submissions about the Handloom Handicraft Corporation. That is not an issue before his honorable court. The NIDC has been an issue before his court on multiple occasions. And the state, your leadership will
Can you
appreciate.
remember any of those NIDC judgments regarding retirement?
I can
Because
furnish it later on.
ultimately, this seems to be the main crux now.
I can furnish it later on, your leadership. I can furnish it later on.
Anyone, yeah.
Yes, your leadership. Thank you. No, even otherwise, your leadership, even if the Retirement
No,
Act
just
is
for
not
my
applicable.
satisfaction. Yeah.
Yes. I'll do that. Much obliged for a very patient hearing, your leadership.
Marathon, 3 days, no,
Okay.
4 days.
Yes.
Lieutenant Counsel A. Zimani for the petitioner, Lieutenant Counsel L. Irabu for respondent number 1 and 2, and Mr. Takamasa, Senior Counsel, assisted by Mr. Arndong for the respondent number 3. Judgment reserved.
For hearing, item number 27.
Only 4 minutes left.
Yes, I
So
think
after
we
the
better
break,
come
Lordship.
back at 2.
Lordship.
Whole day.
40 minutes, 30 to 40 minutes.
After that,
अपना कोर्ट ले एक बार सब को Kira-kira item baki আছে sabo. Huh? After 27, 30, 31 আছে. Then 34, 35 আছে. 39. Wait, the last আছে. May, please, Lord.
Yes.
Well, I'd like to mention from supplementary hearing is item 39.
Yes,
That-
I think we won't be able to.
Yes,
pick
that's
up the
why,
other
that's why, my
cases.
lord.
Yes.
I've already taken the concern of the other party.
Okay. Item
Let this
30.
matter come up on 16 June. That's fixed, I think.
16 June on the prayer of the Lord's Council for the parties.
Masuk.
Yeah, please, Lordship. Lordship, the petitioner hearing is the mother of disease common employee and is equipped by non-settlement of family pension.
The other side.
All the parties are present, Lordship. Lordship, before I refer to the documents, the gist of my case is, Lordship, in the year 1995,
It's an earlier hearing item. This one is also the- Yeah, yeah, same. Yes.
the petitioner's son was appointed
Mm.
as officer grade 2 under the Department of Rural Development, Lordship.
Mm.
After serving for more than 8 years, the petitioner's son was expired on 24/2/2003. And after the death of
Regular employee.
contract employee, Lordship, after the death of my son, Lordship, the department regularized the service of the petitioner's son by order dated 30/10/2003. Now, after regularization, Lordship, the director of the department forwarded the pension papers of the petitioner's son to the accountant general. And reminder was also submitted by the director of the department, Lordship, for settlement of the family pension of the petitioner's son. However, Lordship, till 2019, no action was taken by the AG,
At the time of demise, he was bachelor. He was a bachelor.
Lordship. Therefore, Lordship, for non-consideration of the case of the petitioner's sons for grant of family pension, the petitioner approached the Honorable Court filing this writ petition. Respondent number 1, 2, 3 are the state respondents, Lordship, and respondent 4 is the accountant general. Before I refer to the affidavit filed by the state respondents, Lordship, the accountant general, by filing affidavit in opposition, have made a categorical statement that pension papers in respect of the petitioner's son, which was submitted by the department in the year 2003, as well as reminder submitted in the year 2015, is not traceable in the accountant general office. Therefore, the accountant general requested the state government to resubmit the pension papers in respect of the petitioner late son for the purpose of settlement of family pension. That is the stand of the accountant general, and that is a part of record. The letter submitted by the accountant general to the director of rural development is also enclosed in the affidavit, Lordship. Now, Lordship, I'll take your Lordship to the annexures. Page 19, Lordship. Is the appointment order of the petitioner's son. Next page is the type copy, Lordship. This is order dated 17 May 1995. Shri W.M. Nambaran Jami is hereby appointed to the post of Officer Grade 2 Civil on contract basis for 1 year under the Department of Rural Development Block Nakalin and Scale B of so plus all other allowances as are admissible under the rules from time to time with effect from the date of exchange. If the amendment is acceptable to Shri WM Namarin Jamir should report to this agreed for signing so within 20 days from the issue of this order and posted to the office of the BDO Mangulamba and place of Shri so officer who has already resigned. The amendment was made against clear vacancy. Sanction was. In the pensionable establishment, Lordship. Page 23, Lordship. This is the death certificate issued by the concerned authority. The petitioner, after serving for 7 years and 9 months, expired on 24/2003. Page 23.
Appointment was May
95. However, Lordship, in my case, the question of length of service, qualified length of service doesn't arise here. In view of the subsequent regularization. And Lordship, the regularization of order of the petitioner decision is at page 24. Twenty-five is the type copy, Lordship. Lordship. This order dated 30 October 2003. The contract service in respect of Shri so is regularized with effect from 1/5/2000 and scale B of so plus all other allowances as are admissible and enforced from time to time in Nakani. In terms of the government order, the subject, the contract allowances will cease to draw from the date of his service regularization, that is 1/5/2000. This entire service, including the contract service, will count towards his pension provided he forgoed the government contribution in his contributory provider fund plus interest record in such government contribution. So this is the regularization order, Lordship. The petitioner son expired on 24/2003. And after the death of the petitioner's son, Lordship, this is the order dated 30th October 2003. My son's service was regularized by the government for the purpose of pension. Page 27. After the death of my son, Lordship, GAIs was sanctioned. And payment was made to the petitioner, who is the mother, Lordship. And page 28, life engagement was also granted to the petitioner. This is 2004. And page 29. This is the letter submitted by the director to the Accountant General in the month of January 2005. Narrate, Lordship.
to AG.
Page 29. Do the Accountant General, Nagaling Kohima, forwarding of the pension papers in respect of late Emnamaran issue 2. With reference to the subject cited above, I have the honor to forward here with the pension papers as listed in annexure in respect of late Emnamaran who expired on 24/2003 for your further necessary action. This is later dated mail January 2005. Lordship, may kindly come to page, I'm not referring to page 30 and 31, page 32. Despite pension waivers of my son was submitted to the Accounting General by the Department Lordship, no action was taken by the AG for settlement of pension. Therefore, the petitioner on 31/5/2016 submitted a representation to the director, reminding about non-settlement of pension, Lordship. Page 32, may I read, Lordship? Bureau of Settlement of Family Pension in respect of less Namaran, SO or the block Ongbangong North. With reference to the subject stated above, I have the honor to state that my son, late Suisu, was a regular employee of the Department of Rural Development, Nagaland, in Kohima, holding the post of SU2 under Rural Development Block Ongbangong North. In this connection, I would like to state that he expired on 24/2003. Since I am the sole dependent and legal nominee of late Namaran, I've applied for family pension during the year 2005, and still the matter is not settled by the concerned authority. Therefore, I fervently request you kind authority to initiate necessary action from your end for settlement of family pension from the AG office Nagaland at the earliest. This is the representation submitted by the petitioner on page 33. This is letter dated 16 June 2016, written by the Director, Rural Development to the Accountant General, requesting for early settlement of the family pension in respect of the petitioner's son. Do the Accountant General Nagaland Kohima, subject forwarding of application received for settlement of family pension case in respect of late number X issue 2 under RD block so and so. And embedding a reference to the above subject, I have the honor to forward herewith an application in original received from Shrimati to Shimala, mother and legal nominee of late number issue 2 for settlement of family pension, for which the application itself is self-explanatory. And this connection, this is to certify that the family pension case in respect of the above thesis in government was duly forwarded to the AG by this office letter number so dated 11/7/2005. However, intimation of the settlement for this family pension case by AG has not been received by the department. Moreover, no sanction has been made towards family pension in respect of late number X is or too far as this office is concerned. Hence, for paper of your further necessary action for settlement of the said family pension case. This is the letter of the Director of the Department Lordship. Despite repeated reminder from the department, AG failed to settle the family pension. Therefore, the petitioner submitted a representation to the Accountant General in the year 2019, page 34. This no action was taken by the AG to the representation. The petitioner approached this court by filing the instant rate petition. Lordship. Therefore, I refer to the affidavit filed by the still respondent. Altogether, still respondent have filed 5 affidavits, including 4 additional affidavits. So before I take your lordship to the affidavits filed by the state respondent, I may allow to refer to the affidavit of Accountant General. Two affidavit has been filed by the AG, lordship. Two affidavit by the AG. One is affidavit in opposition by the Accountant General.
AG is 4.
Yes. And another is additional affidavit. There are more than
Additional
5
affidavit.
additional affidavits, Lordship.
Yes, additional affidavit. The-
Additional affidavit of respondent number 4.
Additional affidavit of respondent number 4.
Additional, in the cost title, additional affidavit in compliance to the order dated 23/9/24.
Yes, yes.
Lordship, will kindly
Filed
come to
on
Bishop.
19 November 24.
Yes, Lordship.
Mm.
Page number 11. I'm not reading the affidavit, Lordship.
Page 11.
Yes. Last page, Lordship. This is a letter dated 6/7/2022. Submitted, written from the AG to the Director of Rural Development. Do the Director of Rural Development, Nagaland Kohima, family pension case in respect of late WM number and X issue 2. Sir, please refer to your letter number so that is 16/6/2016. Going close regarding settlement of family pension in respect of late WM number and X issue grade 2. Under your development, in this regard, I am to state that the original pension documents which was stated to have been submitted by your letter number so dated 11/7/2005 is not traceable, could not be located in this office. You are therefore requested to submit copies of the pension documents to this office at an early date for scrutiny and settling the pension case. Now, it is the case of the Accountant General that the pension papers are not traceable. Therefore, request has been made to the Director of the Rural Development to furnish the necessary pension papers. So that is the stand of the Accountant General. Now, Lordship, by filing affidavit by respondent number 1, 2, and 3, because joint affidavit in opposition has been filed by respondent number 1, 2, and
1,
3,
2, and 3.
including the Director, Lordship.
So many affidavits are there.
It is, apart from the affidavit of session, there are 4 additional affidavit which was filed by the respondents pursuant to several direction issued by the Honorable. I'll refer to that later on, Lordship. Now, by filing affidavit in opposition by respondent number 1, 2, and 3, including the Director, Lordship, they have taken a specific stand
First one is
affidavit in opposition.
of 13 April 2023, filed on 13 April 2023.
That is an affidavit in opposition, Lordship.
Yes.
Yes.
On behalf of respondent number 1,
Yes.
2, and 3.
The stand of respondent number 1, 2, and 3 is that, Lordship, the regularization of the service of the petitioner's late son was illegal because Director has no authority to regularize the service of the petitioner's late son. That is the specific stand taken by the respondent in the affidavit. Therefore, the petitioner, who is the mother of the deceased government employees, is not entitled for family pension. That is the stand of the respondent, that Director had no authority to regularize the service of the petitioner's son in the year 2003. That is the stand, Lordship. Director regularized the service of my son in the year 2003. And the affidavit in opposition is also filed by the director, demeaning his own action, Lordship, taking the contrary stand, Lordship, to the earlier action. Kindly peruse my regularization order of my lesson, Lordship. That was issued by the director. I'm not denying that, Lordship. And now by filing affidavit in opposition, the director is against taking a contradictory stand that director has no authority.
Director is R3.
R3, Lordship. Whether such contradictory stand is permissible under the law? No, Lordship. Lordship, kindly. I'm referring to para 4, 5, 6, 7, and 8 of the government affidavit. Affidavit in opposition, Lordship. Affidavit in opposition of respondent 1, 2, and 3.
Para 5.
Bara 4, Lordship. Your stand is at bara 4. That with regard to the statement made in paragraph 2, 3, 4, 5 of the writ petition, the deponent does not admit anything which is contrary to records. The answering deponent further states that the petitioner's son, late Suinsu, was initially appointed as officer Suinsu in the year 1995, and his service was extended from time to time in the same creed till his demise on 24/2003, as admitted by the petitioner herself. The petitioner's son, late W. Suinsu died while he was still in service. That is the statement of the respondent on contract basis. Being such, the question of pension doesn't arise. Number 5, paragraph 5. Then with regard to the statements made in paragraph 6 of the writ petition, the answering deponent begged to state that the service of the petitioner's son, late Suinsu, was supposedly regularized posthumously on 30/2003 with effect from 1/5/2000. And that is after 8 months from the date of his death, without the approval of the government, and that too at the directorate level, which is not the competent authority. That is their stand, Lordship. Any regularization of the contract service can be carried out only with the proper approval of the government after following due process of law with clearance, concurrence of the Pioneer Finance Public Service Commission. On this issue, of the petitioner claimed that his late son's service was regularized, considering the dedicated service to enter, and that too without any approval of the government, which is mandatory, cannot stand the test of law. If the petitioner's claim that his late, it should be her, son's service was regularized by the government, the petitioner may be both to strike proof of the same, whether the government has accorded its approval for such regularization as mandated by law. 6, 7, same thing, same stand, Lordship. In view of this stand, contradictory stand taken by the director, Lordship, certain information has been sought from the directorate under RDI. Lordship, earlier occasion, I have submitted the documents furnished through the RDI. If it is available, if it is not available, I have extra copy, Lordship.
This one.
No. Seeking information from the directorate, the appointment made and the regularization made by the director during that period, that is 1995 to 2003, Lordship. Lordship, which one is the letter from the department Page 2, Lordship. This is later dated 1/11/2023, Lordship, correct?
Yes.
Do so and so, advocate so and so, furnishing of information under RDI Act 2005. And inviting a reference to your RDI application number so and so, I am to inform you that the information sought by you is ready in this record so and so. Next page, Lordship, page 3. This is order dated 11 August 2006, after regularization of the petitioner's late son's service. Lordship. Lordship, may kindly see. Shiri so sectional assistant on casual service under this directorate is hereby regularized. And the boss of server grade 3 against the boss regarded by so. This casual service of sectional assistant was regularized by the director, Lordship, after the regularization of my son by the director. Next page. This is also 2004, after the death of my son, Lordship. This is appointment order, Lordship. Shri so, son of so, village so, serving under so, Mon, on contingency basis, is hereby temporarily appointed to the post of confused peon under so. So this appointment was made by the director.
But this is
After-
grade 4, no? Grade
Correct,
4
Lordship,
appointment,
correct.
yes.
This is the documents furnished by the department, Lordship.
Yours is grade 2.
Yes. And page 5. This is order dated 23/5/2006. And the interest of public service, Shri Su LD, appointed against temporary officiating promotion vacancy under the establishment of Directorate of Rural Development, Nagaland, hereby appointed as LD Community Assistant. So. This is also appointment order made by the director. And page 6. This also regularization observation order issued by the director in the year 2010. All these documents shows that the director of the department has the authority for appointment to the grade 2 and 3 posts. And also had authority to regularize the services during that period of time. I'm not concerned about notarial lordship. We are concerned about 2003. Now, in view of the Gondori stand taken by the state respondent's lordship, this honorable court by order dated 29/9/2024,
9/9/2024.
is, has lordship got it? By filing additional affidavit by the state respondent, this order is also enclosed, lordship. I'm referring to the additional affidavit, lordship.
additional affidavit of
State respondent, Lordship.
1, 2, and 3.
Additional filing of an affidavit by state respondent 1, 2, and 3 as per the Honorable High Court order dated 29/7/25. Affidavit filed pursuant to order dated.
29/7, yes.
Yes. Can you come to page 5, Lordship, of the affidavit? Page 5,
Eight.
Lordship.
Rosa, are there any more items left after this?
Yes.
I don't think we want to take any. Let's see. Yes.
Yes. This is the order passed by this court, Lordship.
Mm.
Dated 29/7/24. MS in a holy government advocate shall on the next date fix file an affidavit stating as to whether the order dated 30/10/2023 issued by the government of Nagaland Rural Development Block, Nagaland, Kohima, posthumously regularizing the service of late W. Suinso has been recalled by the government as on date. Listed on again on 12 Suinso. It is made clear that if an affidavit is filed as directed by this court,
If no affidavit.
if no, Lordship, timing mistake, shall be taken that no order has been issued by the government recalling the order to the Suinso, posthumously goes to Suinso. Next page, Lordship. This is a letter to the concerned government advocate pursuant to the court's order. To Suinso. Submission of Baraway's instruction governments in application number Suinso, Seniority Suinso, State of Nagaland, and others. Madam, and inviting a reference to your letter number Suinso, dated Suinso, and as per available records, it is to inform you that as per the available records under DRT, the issue of illegal posthumous regularization, they are talking about illegal, Lordship, order dated 30/10/2023 came to light only after filing of the writ petition and could not act under order as the matter was already sub judice before the Honorable High Court and therefore has not been recalled by the Department as on date. This Honorable Court made inquiry whether regularization order of the petitioner late son is still stand revoked or not. And by filing this affidavit, Lordship, specific statement has been made that regularization order is not been revoked. Now again, Lordship. Taking into consideration of the stand taken in the affidavit negotiation by the state respondent, Lordship, that director has no authority for regularization. This Honorable Court, Lordship, I'm referring to an additional affidavit filed pursuant to this Honorable Court's order dated 2/9/24.
Yes. This is also 1, 2, and 3.
Yes, Lordship. Page 4. Page 4, Lordship. Court's order. I'm not reading the contents of the affidavit, Lordship. Page 5 is the relevant. But Lordship. Order dated 2/9/24. MS in a holy learned government advocate shall on next date file an affidavit stating as to who is the authority competent to make appointment to the board of Professor Grade 2 civil on contract basis. The instruction sought for shall be in context of the petitioner of the present case, who was appointed as officer grade 2 civil by the Directorate of Rural Development Block so on so. Listed on the next page, Lordship. Later dated 5th September 24. To Shrimati so Government Advocate, Lordship. Subject, wording of Honorable Court's order dated so and seeking of further instruction, comments pertaining to tabulation number so. Madam, in inviting a reference to your letter number dated 3rd September 24, I am directed to refer to the subject cited above and to inform you that Director Rural Development is committed to make appointment to the post of officer grade 2 civil on contract basis during period 1985. So this is a part of record in the affidavit of the state respondents. Two more additional affidavit has been filed, but then I'm not referring to that affidavit because all the documents annexed in that affidavit are not relevant at all in view of the letter issued by the government to the government advocate regarding the authority of the director for appointment as well as the regularization. Therefore, Lordship, my submission is that the regularization order of my late son is still valid, not revoked. And therefore, in view of regularization, I am entitled for the being a mother of the deceased government employee. I'm entitled for the family pension. From the documents annexed in the affidavit in opposition and affidavit, additional affidavit, Lordship, it is very clear that director has the authority, Lordship, for appointment for regularization. Therefore, they cannot take understand that no, director is no authority for regularization of the employees. Even assuming, Lordship, there is personal lapses on the part of the authorities, the petitioner should not be made victim of the lapses and the negligence on the part of the authorities, Lordship. Now the respondent is talking about director has no authority, has no power to regularize. However, as per the available records, which was obtained through the RDA, and the leader of the government itself shows the director has authority. Therefore, the statement taken in the affidavit of position is contradictory to their own actions, and such a statement has been made just with the motive to deny the family pension to the present petitioner, Lordship. Lordship, with regard to contradictory stand taken by the respondents, Lordship, because appointment was made by the director, regularization of my son was by the director, and the affidavit in opposition filed by the state respondent, including the director, have taken a contradictory stand. To the earlier action, Lordship, I'm just referring to one decision, Lordship, of this Honorable Court. 2010 3 GLD page 150. I'm just referring to paragraph 1, Lordship. Paragraph 11, Lordship. Bara 11. Bara 11, I'm reading Bara 11, Lordship. The apex court in Union Derisory of Suinso and others versus Rajesh Kumar Suinso 2003-11 ACC 549 held that a party cannot take a stand which becomes contrary to its own conduct. In the instant case, the Director of Education Suinso of Manipur had taken a stand in the affidavit in opposition filed in the present writ petition contrary to the stand in its letter dated 27/7/2025, which is not permissible because of the ratio descending in Rajesh Kumar. Same Lordship. Director made appointment, regularization was done by Director. However, by filing affidavit in opposition, he's taken a contrary stand. That Director has no authority. So this principle laid on by the apex court will apply in the present case, Lordship. Therefore, Lordship, unless and until my regularization order is cancelled or revoked, I'm entitled for the family patient. And the petitioner, who is an aged Toman Lordship, is waiting for settlement of family pension for more than 20 years, Lordship. More than 20 years, he's waiting for the family pension of his son. And after 20 years that is filing the writ petition, the state respondent is coming with a stand that no, you are not entitled for family pension because regularization was not by the government, but by the Director has no authority. Whether such an action after lapse of 20 years is permissible, Lordship. Therefore, the action of the respondent authorities, Lordship, is totally illegal and direction may be issued to the respondent to furnish the pension papers forthwith to the Accountant General assault by the Accountant General in their letter of 2022. And direction may be issued to settle the family pension of the petitioner late son, Lordship. That is my submission, Lordship. Obligatory.
I appreciate leadership, Your Lordship. I'm thankful to the learned counsel because he's referred to all my affidavit, but Your Lordship, I would also like to refer to, before my submission, Your Lordship, I would like to take you to my counter affidavit, Your Lordship. Dated 13/4/2023. Dated 13/4/2023.
Filed on 13/4.
Yes, 13/4/2023. The counter affidavit, Your Lordship.
Just now I saw it. Yes, 13 for.
Yes, Your Lordship, page 2, Your Lordship. Your Lordship, I would like to read out the paragraph 5 and 7, Your Lordship. Though the petitioner had already brought this before Your Lordship, but I would also like to rely on this, Your Lordship. Paragraph 5, Your Lordship, if I may be allowed to read, Your Lordship.
Paragraph 5.
Yes, Your Lord, paragraph 5. I may be allowed to read. That with regard to the statement made in paragraph 6 of the writ petition, the answering deponent begs to state that the service of the petitioner's son, led W. Imna Miran, was supposedly regularized posthumously on such and such, that is after 8 months from the date of his death, without the approval of the government, and that too at the directorate level, which is not the competent authority. Any regularization of contract services can be carried out only with the proper approval of the government after following the due process of law with the clearance concurrence of the PNR, Finance and Public Service Commission. On this issue of the petitioner's claim that his late son's service was regularized, considering the dedicated service rendered, that too without the approval of the government, which is mandatory, cannot stand the test of law. If the petitioner's claim that his late son's service was regularized by the department, the petitioner may be put to strict proof of the same as to whether the government had accorded it approval for such regularization as mandated by law. Para 7, Your Lordship. That with regard to the statement made at paragraph 9 of the writ petition, the answering department denies the same. As stated above, since there was no record to show that the service of the petitioner's son, led W. Imna Miran, was regularized with the approval of the government, his family pensions were never forwarded to the Office of the Accountant General. There is no record in the government level whereby the family pension of the petitioner's led son, W. Imna Miran, was forwarded to the Accountant General. Your Lordship, with regard to this, Your Lordship, the AG also concurs that there is no record with the AG, Your Lordship. In the AG's counter affidavit, Your Lordship, in para 5, they've also stated the same law, that there is no record with the AG, Your Lordship. And Your Lordship, with regard to appointment, Your Lordship, as the petitioner has drawn Your Lordship attention to the affidavit filed on additional affidavit, which was filed on 6/9/2024. This is in pursuance to the court's order 2/9/2024. The date of filing is 6/9/2024. Yes. Your Lordship, in Annexure B, page 6, Your Lordship, we have stated that the particularly this Annexure B, Your Lordship, is making a statement that the director, this is not with regard to regularization, this is with regard to appointment, that the director is not the competent, that the director is the competent authority to make appointment during that period. But Your Lordship, I would also like to, in this connection, Your Lordship, I would also like to take Your Lordship to my additional affidavit, which was filed on 27/2/2025. Yes, page 6. Annexure B.
Appointment to gazetted.
Yes, Your Lordship, I would like to read out this OM, Your Lordship. If I may, Your Lord, Your Ladyship.
Yes.
Though the director was the competent authority to make appointment in that particular year, this OM was also in existence. So I would like to rely on this OM. This is OM dated 2nd November 1972. Subject: appointment to gazetted and non-gazetted, both technical and non-technical posts under the state government. The undersigned is directed to say that in the interest of public, the government of Nagaland have
taken the following decisions in matters of appointment, employment under the government of Nagaland, both technical and non-technical, gazetted and non-gazetted posts. All cases of appointment to technical posts, both gazetted and non-technical gazetted posts, preference should be given to the indigenous local people. All cases of appointment to non-gazetted and non-technical posts in the state of Nagaland should be reserved for the indigenous local people of the state. All cases of appointment in the state to non-gazetted and gazetted posts, both technical and non-technical on contract basis, shall be done with the prior approval of the cabinet. Your Lordship, this is important. 6. And after that, all appointing authorities of the government of Nagaland shall therefore comply with above decision of the government in all cases of future appointment. Lordship, therefore, the first appointment itself, Your Lordship, is in violation of this OM, Your Lordship. So the appointment itself is void ab initio. Though the director may be the appointing authority, he has to take the approval of the cabinet, Your Lordship, as per this OM. So his first appointment as on contract basis itself is void, Your Lordship. And with regard to regularization, Your Lordship, I would like to take Your Lordship to my additional affidavit, which was filed on 22nd May 2024. Yes. Your Lordship, from the affidavit, I'd like to page 3, paragraph 4. This is a continuation, but I would like to read from page 4. Continuation from page 3, but I would like to read the the page 4 paragraph, Your Lordship. Your Lordship has got it?
Yes.
The deponent, I'd like to read from the deponent. The deponent would also like to place on record the Nagaland rules of executive. It should be executive business. The executive business, page 4.
Oh, page 4.
Yes. This paragraph is a continuation from page 3, but I would like to read from page 4.
The deponent would also.
Yes, the deponent would also like to place on record the Nagaland Rules of Executive Business 1980, which was in force at the time when the petitioner's son was regularized, particularly Rule 10.1, which states that no department shall, without previous consultation with the Finance Department, authorize any orders other than orders pursuant to any general delegation made by the Finance Department, which either immediately or by their repercussion will affect the finance of the state. Your Lordship, so this will prove that regularization, it involves financial implications. So it is tried in law that for regularization, Your Lordship, approval has to be taken from the government. So his approval without taking, yes, sorry, Your Lordship, his regularization without taking approval from the government is illegal. And it's against this rule 10 of the rules of executive business.
So many years, nothing was done. If you knew that it was illegal.
Your Lordship, as stated in my affidavit, it came to light only when the affidavit was filed, because the regularization was done in the year 2003. And the writ petition had been filed in the year 2022, more than 10 years, after 10 years. So this came to light only after filing of the writ petition. And with regard to the
same officer who appointed and regularized is now saying that it is illegal.
Your Lordship, with regard to the RTI documents which the petitioner had placed, Your Lordship, the petitioner had placed documents showing that after the petitioner's regularization was done by the director, there were other regularization. Yes, Your Lordship, in reply to that, I also placed one document which shows that in the year 2005, that was after the petitioner was regularized, the 34 regularization was done, which was done after the approval of the government. So this will also prove that regularization is mandatory. Well, Your Lordship, my submission will be on 3 points. That his first appointment was void, and appointment on contract basis was void ab initio because it was in violation of the OM dated 1972, and the posthumous regularization was also done without the government approval, which was against the rules of executive business 1980, and that during his lifetime, he was not entitled for regularization, but he was regularized after the decease. And Your Lordship, I would like to rely on one Supreme Court's decision. Page 474. This is on proposition that when without making appointment without authority is nullity in law. I would like to read from para 19 and 20, Your Lordship. Paragraph 19 and 20, page 474.
Yes.
19, paragraph 19. We shall now consider the efficacy of the reasons so rendered in the office order. The recruitment procedure in relation to the post of veterinary compounder is governed by the statutory rules titled Central Cattle Breeding Farm such and such, 1969, as amended from time to time, and including the executive instruction issued in that behalf. As per the stated dispensation for such recruitment, the appointment letter could be issued only by an authorized officer and after grant of approval by the competent authority. Nowhere in the original application filed by the respondent it has been asserted that such prior approval is not the quintessence for issuing a letter of appointment. For taking this contention forward, we may assume for time being that the then director in charge as H.S. Rathore, agriculture officer, had the authority to issue a letter of appointment. Nevertheless, he could do so only upon obtaining prior written approval of the competent authority. No case has been made out in the original application that the due approval was granted by the competent authority before issuance of the letter of appointment to the respondent. Thus, it is indisputable that no prior approval of the competent authority was given for the appointment of the respondent. In such a case, the next logical issue that arises for consideration is whether the appointment letter issued to the respondent would be a case of nullity or mere irregularity. If it is a case of nullity, affording opportunity to the incumbent would be a mere formality, and non-grant of opportunity may not vitiate the final decision of termination of his services. The tribunal has rightly held that in absence of a prior approval of the competent authority, the director in charge could not have hastened issuance of the appointment letter. The act and commission and omission of the then director in charge would therefore suffer from the vice of lack of authority and nullity and law. So, Your Lordship, my submission is that his first appointment on contract was nullity in law, void ab initio. So the question of regularization and the regularization would also not arise, Your Lordship, because the contract appointment itself was nullity in law. I mean, I would like to raise my case from here, Your Lordship. Therefore, the petitioner has no right to claim for family pension as his initial appointment is nullity in law, and the regularization was also without any approval from the government. Therefore, it's an illegal order, Your Lordship. I raise my case.
May it please your lordship. My lord, I'm appearing on behalf of my senior Joseph for respondent number 4, accounting general.
Your submission is only that you have not
Lordship,
received.
yes.
Yes.
Lordship, only one clarification with regard to my appointment of my son, Lordship. When was made in the year 1995 by the director. Salary was paid by the government, Lordship. All along. After it also, GIS and life engagement was granted by the government, Lordship. And now, after the appointment of the petitioner list son, it's more than nearly 25 years, Lordship. Respondents are questioning my appointment. That my son appointment was illegal, null and void, in view of one of his memorandum, which is annexed in the affidavit, original affidavit filed by the respondent. Whether such submission may be accepted at this stage, Lordship. And I'm repeatedly submitting, Lordship, my regularization order has not been cancelled, revoked by any authority till date. Therefore, I have a right for the family pension unrestrained after regularization order. Regarding the decision referred to my learned friend, Lordship, there was a statutory service role in that case, Lordship. Here, in this case, there is no statutory roles. My son appointment was not met against the statutory service role, Lordship. Whereas in that case, there was statutory roles and appointment later was issued contrary to the statutory roles. So that there's difference between the decision referred to and the present case, Lordship. Obligation. But
Hearing, item number 31.
I think this will be the last. Any more after this? I think not possible.
Yes, I understand.
And there's only so much I can take also.
And in leadership, again, if I may seek your indulgence like yesterday,
Yes.
if my learned friend can finish, the matter can be kept path her so that next time can be taken up early.
Maybe
Yes, your
we
leadership.
can
Yes.
finish his part and then.
For that I cannot assure because I said
Oh, you can start.
lengthy matter, my lord.
He can start today.
To finish off this matter, I will need some time, for at least my part, my lord. And
that's why you can start.
That's why
So some,
you can start and then you finish your submission and his submission can be done another day.
My learned friend is probably saying that he cannot finish today.
You cannot finish today.
no, lordship, it will not be possible to finish in one day.
But can we still start, your leadership? Can we still start?
Lordship, if it is not very inconvenient, can a date be fixed then, which we? Because it's better if both the parties are arguing this matter on
No, you don't want to stay back.
I will have to move my friend comes from Delhi, my lord. He will also have, he has already booked his ticket. That's the difficulty, my lord. Otherwise.
No, what we can do is start and then keep it part heard. Part heard, and then fix another day when it's according to your convenience. That can also be done.
Yes.
It's up to you, but
You can start.
it's up to you.
So my lord, in that case, your ladyship may I be excused today also. My junior will be here.
Okay.
Much obliged.
Well, this is an application under 528 of BNSS, my lord.
Oh, yes. I think that one we need to pass order first. Are they online? Are they? Actually, Learned Council, there are two anticipatory bill matters where we need to pass some short orders. Okay, we'll just take it up first.
For hearing, item numbers 34 and 35.
Yes.
May I please, your lordship, for 34 and 35, your lordship?
Yes, you were telling me about one affidavit.
Lordship, one additional affidavit which we have filed yesterday, your lordship. What has happened in this case, your lordship? Lordship, on 27/5/2025, this honorable court has passed an order directing me to appear before the Commissioner of Police, your lordship, on 31/5/2025, your lordship. Thereafter, lordship, inadvertently on 31/5/2025, there was a flood situation at Gauhati, your lordship, and therefore I could not travel to Dimapur to record my statement, your lordship. And your lordship has passed this order on 27/5/2025, which is at page number 7, and the relevant portion is at page number 9, your lordship, of my additional affidavit. And in connection, lordship, is I am audible, lordship?
Yes. Page 7.
Yes, your lordship. Page 7, and relevant portion is at page 9, your lordship. The direction is at page number 9, your lordship.
31/5.
Lordship.
31/5.
Yes, your lordship. But surprisingly, your lordship, you may also see the next page, your lordship. At page number 10, your lordship, there is a press release also that exceptionally heavy rainfall affected the state today, your lordship. This is dated May 30, 2025, your lordship. My only prayer is that thereafter I have also annexed the newspaper cuttings and all, your lordship.
Okay, so
My
when can you appear then?
Lordship, if it is on 5th, your lordship, if possible for your lordship,
No. I mean, when can you appear before the Commissioner of Police?
Office of
On 5th, I can appear, your lordship.
Office of the Commissioner of Police.
Yes, your lordship. 5th, your lordship. 5th of June, this month, your lordship.
That is Thursday. Okay. An additional affidavit has been filed by the deponent / petitioner, praying for another date to appear before the Office of the Commissioner of Police, Nagaland, as directed by this court by order dated 27/5/2025. Stop. Learned Counsel, appearing for the petitioner, Mr. Haloy, DJ Haloy.
Lordship, DJ Haloy.
Submitted that this court by order dated 27/5/2025 had directed the petitioner to appear before the Office of the Commissioner of Nagaland on 31/5/2025 between 12 p.m. to 2 p.m. for the purpose of recording his statement in connection with this case. Stop. And thereafter to list this matter on list this matter today, that is 3/6/2025. Stop. Learned Counsel submits that due to heavy rainfall and flooding in the state of Assam, he was unable to travel to Dimapur as directed by this court. And has enclosed the weather reports and photographs to that effect. Stop. Learned counsel therefore prays that this court may fix another date, that is 5th June, for his appearance before the office of the Commissioner of Police and to list the matter on. Then this will take up on Monday,
On 12th, your lordship, if it is convenient to your lordship.
12th. 12th is okay, Mr. Hangami.
And if lordship fix up the time as before your lordship, that would be more convenient, your lordship. For appearance, your lordship, before the commissioner.
Just wait, and thereafter to fix this matter on 12th of June, 2025. Stop. Learned Council, Learned PP K. Hangami has no objections to the said prayer. Stop. Accordingly, it is directed that the petitioner shall appear before the office of Commissioner of Police Nagaland on 5/6/2025 between 12 PM to 2 PM and record his statement in connection with this case. Stop. And list this matter on. 12.
My lady, if the last sentence also can be included.
To cooperate.
No, the petitioner further direct to make an entry in the official register
Okay.
if he fails to meet the
So,
IO.
the petitioner is further directed to make the entry in the office register if he fails to meet the IO. Stop. Accordingly, list the matter 12/6.
And your lordship, my interim may also be continued till then, your lordship,
The interim order
till next date, your lordship.
till the next date.
And 35 also same, your lordship. The petitioner is different only.
Okay, same order, but name of the petitioner will be different.
Blush.
Much obliged.
Okay, yes.
Lordship, one thing is this, subject to what your lordship may say. Actually, I will take some time in this matter. It will be time consuming and I have to solve your lordship, place some judgments also, apex court. So can it be such that, can we have a date after the summer vacation, my lord?
No,
After
it's
14th of June.
perfectly fine with the court. It's up to you, up to your convenience.
So I will not be able to, again,
Come
it will
back.
today I will not be able to finish. Again, another date will be fixed. Again, I will have to continue the argument from one point. It's better, at least I can get a opportunity.
You want to finish at one go?
At one go, lordship, that is the thing.
Okay. When?
July, after 14th of July,
Our vacation is still 12.
12,
Yes.
14th, I think,
Let it be 15th or something, 15th or 17th.
maybe by 15th, my lord. 15th or my lord, 15th, I think is a Tuesday. 24th,
Just say.
24th will be.
paucity of time.
24th.
List the matter on 24th.
24th.
24th is okay. 24th of July for hearing on the prayer of the houses for the parties.
Another small indulgence, my lord,
Yes,
if it is
yes.
permissible at all.
Yes.
Can it be mentioned that matter will be taken up at 2, my lord? Then at least we have some time to. Will not bother your lordship in the earlier part of the court's business, but from 2 or 2 o'clock at least, my lord, if.
That I don't know, because, yes,
If.
because see, morning hours, again, it may spill over and then, it will
Yes,
continue again.
No, my lord. So.
Or we can say, first item in the list. or
Yeah,
something.
first item,
Yes,
first item.
yes,
that-
First
that-
item.
First
take it
item,
on.
that will be.
That's all.
And deeply.